matter for 230. The case of premature transfer. Minutes on 10/1/24 minutes I was transferred as a deputy secretary minutes. Deputy secretary minutes in the Department of Ports and Inland Waterways. Minutes in the month of July on 23rd minutes again I've been transferred. This is the second time.
From one seat to another within the same office.
Minutes secretariat minutes. It is an order of transfer.
It's an order of transfer. But what is the right to say that you have to continue in a particular seat?
My tenure minutes is guided minutes by the transfer guidelines 2013.
True.
Minutes I'm a group A officer. Minutes my tenure minutes, minimum tenure minutes is for a period of 2 years. Minutes I approached the KAT. Notice is ordered minutes, no stay is granted without posting minutes.
Yes, listed tomorrow, not 2:30. Please get it numbered and can't be at 2:30. Please.
They pay for the appellant.
Yes, trademark infringement.
Matter wherein
Yes.
not the
Trademark infringement, so Eureka Pro, which is Eureka Pro.
Yes,
But, fine.
every injunction has been.
granted,
Every
I'm challenging that order. Challenging that order. But what has happened is not two things, not. Their main grievance is not the appellants are providing service. And not according to them, it is their customers. Now, Lord, they may have sold Lord, the Eureka Forbes, not their AquaGuard or any other water purifier. But not there's nothing not between them and not the customer. If they have an agreement with the customer, not so the customer will of course go with them. The agreement is not there with the customer. Their grievance is
It's not there.
please not.
Is it open to you to,
Yes, not.
the contention is this,
Please.
that you are attempting to pass off your products as and services as theirs.
Yes, I'll answer that. No, I'm not. I'll just give an example. Not in India, not there are a lot of not Maruti service stations. A lot of people not repair Maruti cars. But if I buy a car, not either it's Maruti or Toyota or any other vehicle, but I need not necessarily go back not to the very same company not for service. But I can go not outside to not same way not.
You don't name it.
Correct.
I mean, suspiciously similar to the.
Absolutely, I bow down
original.
not insofar as not the other defendant is concerned, not Sureka Forbes. But I bow down because of course I don't appear for them. But not there is similarity. Insofar as not my company is concerned, not the name is not Forbes Technovative. I'm not the other not company. He's called not Eon Exens Private Limited. But it has nothing to do with not insofar as the plaintiff is concerned. Now, Lord, what the kindly see the order of the trial court note. The two different things not altogether. Another not legal submission is. But if Lord so kindly see, Lord, they have clubbed two things. But they have a trademark, not according to them, for a particular product. Insofar as Lord Aqua Shore or Aqua Lord Care is concerned, they claim copyright. Now, Lord, whether Lord copyright not can be clubbed with trademark is one not legal contention. Because not there can be a suit for not infringement of copyright. But it cannot be clubbed with a suit not seeking for not infringement of trademark. Because two are different and separate cause of action. Because in fact, not in Dabur case, not
What is the order passed?
But the order passed not by the trial court. Not can I just request not
Initial order of.
initial order not temporary injunction.
Yes.
But that was not. I also filed an application for vacating stay, but which is also rejected by the trial court.
What is the initial order? That has been confirmed.
That has been confirmed.
Yes.
Yes. Annexure A, Lord, is the order.
Initial order.
No, Lord, this is the confirmation order.
Please tell us what is the initial order.
Please, Lord, initial order.
Hmm.
Lord should get it, Lord, along with their statement of objections. Lord, page 85, annexure R9. But initial order, Lord, so please turn to Lord, page 88.
Yes.
But can I request Lord, so please turn to Lord, para 4 there in Lord, at page 89. The suit to the plaintiff for permanent injunction restrain defendants, their partners, principals, employees, etc. from selling, marketing, advertising, exporting or permitting use or supplying the AMC services. Not kindly mark this lot. AMC services, counterfeit filters, motors, etc. by using or applying the trademark of the plaintiff and passing off the work, righted work, Eureka Forbes Home Center, Aquacare, Aquaguard, Aquashore, Forbes, which is similar to that of the plaintiff to trademark. Plaintiff is also sought an injunction, restraining defendants from passing off the goods by using the deceptive trademarks as that of the plaintiff. Plaintiff has also sought for mandatory injunction against the defendants from supplying infringing material in the name of the plaintiff's trademarks and also for rendition of accounts and means profit. Considering the nature of the suit and the materials available on record, at this stage, the plaintiff has made out a prima facie case for grant of injunction as played in IA number 1. If the injunction is not granted, the very purpose of the suit will be frustrated. Hence, the defendants, their proprietors or partners, officers, servants are restrained by an order of injunction from using the trademark. Sureka Forbes Limited. No, I am not no way concerned with Sureka Forbes. Aquacare Ion Exchange. No, that is not respondent number 8.
Ion Exchange.
Yes, Lord. Even I
Yes.
don't appear for them also. There is no such company according to me. I don't know who they are. I am not even appearing for them. They are not Forbes Technovative Private Limited, which is not the appellant before my lords. I am not Eon Exchange Private Limited, which is another appellant, which are similar to that of the plaintiff's registered trademarks till the next date of hearing. No reasoning is given why it has been granted. Plaintiff has also made out sufficient grounds for appointment of court commissioner. Before issuing suit summons, notice on IA number 1 to defendants of court commission has to be appointed for searching the premises of the defendant, seizure of all the deceptive materials as prayed in IA number 2. Plaintiff have already furnished the names of the court commissioner with the memo. Pro access so and so is appointed to court commissioner to visit the offices bar, go down with the defendants without any prior notice to the defendants in order to search and seize the database relating to plaintiff, which may be stored in the computer hard disk, compact disk, servers of any other storage media, and report thereon to the court. Issue court commission warrant in 5 copies, so and so. Not let's skip that portion. Lord, this is the order of the trial court. Now, Lord, please see, Lord, the prayer that is there in the plaint. Can I request, Lord, to please turn to the plaint, Lord, which my Lord should get it. Lord, at page 34, annexure B.
Page
Page 34, Lord,
of
the appeal itself, Lord. The plaint starts there, Lord.
yes,
At page 59, Lord, is the prayer.
yes.
Permanent injunction to restrain defendants 1 to 8, their partners, principals, employees, agents, distributors, franchise, representatives, assigns from manufacturing, selling, marketing, advertising, exporting, and or permitting the use of or supplying their AMC service, counterfeit filters, motors, electrical spares to any third party or clients of the plaintiff who are wrongfully using or in any other manner using or applying the trademark and passing off the copyrighted work, Eureka Forbes. Now, kindly see the language, passing of the copyrighted work. Not Eureka Forbes, your friends for life, Eureka Forbes Home Store, Aquacare, Aquaguard, Aquashore, which is confusingly similar to the plaintiff's registered trademark, Forbes, Aquacare, Aquaguard, Aquashore, or any other trademark deceptively or confusingly similar to the plaintiff's well-known trademark in any manner whatsoever. Permanent injunction to restrain defendants 1 to 8, their partners, principals, employees, agents, etc. from manufacturing, selling, marketing, advertising, exporting, or permitting the use of or supplying their goods or service with the name Sureka Forbes, Forbes Technovative Private Limited, Eon Exchange Private Limited, and Aquacare Eon Exchange to any third party or clients of the plaintiff in any other manner, using the prefix and suffix of the plaintiff's brand name, trade name, or applying the trademarks such as Eureka Forbes, Aquacare, not same thing is repeated. Then C is mandatory injunction.
Please tell us what, according to you, are you doing?
What I am doing, Lord?
Yes,
But can I just-
your contention in the suit.
But my contention in the suit is not, insofar as not I am concerned, not I am also registered. I'm a registered company. Lord, I have not. If not, so please turn to. Can I just pass on, Lord, the filters, Lord, just to compare. But only point out, Lord, they don't manufacture these not candles. These filters not are manufactured by a different company.
That is
Which
not
is-
that is actually not the issue at all.
Please.
Are you attempting to impersonate them and pass off?
No, Lord,
as-
I am not
as
impersonating them at all.
That.
Please.
Second is, are you passing off your products as theirs?
No, Lord.
And are you attempting to, what according to you are you
Lord,
doing?
I am providing service.
Hmm.
Lord, I am
As
not a water purifier, Lord, I have a service is
you,
provided.
do you have water purifiers?
They don't manufacture.
Lord, I don't manufacture. Lord, in
You
fact,
manufacture only the candles.
Lord, I don't manufacture candles as well.
Hmm.
Lord, I also purchase not these candles from a third party.
Hmm.
So does not the plaintiff.
Hmm.
Lord, even they don't manufacture, even according to my instruction, they also purchase.
Hmm.
Now, Lord, I am not provide for service.
Hmm.
But I have collected the data not from a third party. Lord, I have paid and purchased the data of not various not people in Bangalore,
Hmm.
in Karnataka.
Hmm.
I think I can finish. Can you
Hmm.
can please
Sure.
make submissions? Now, Lord, those data is available in public domain. I have purchased those data. Lord, I am providing for service. Now, Lord, if my Lord may kindly permit me just show the order of the trial court. But the grievance of the plaintiff is one, that you are trying to provide service to my customer to whom I sold AquaGuard.
Again,
Please.
the prayer is just this, not that you should not provide service or AMC, that you should not provide service or AMC as them,
True.
styling, attempting to pass off as them, or use their trademark as yours. That
But
is
I am
all
not
the-
using their trademark.
That is
Why?
all that is all you've been restrained from doing. If you go to a customer
Please.
and make it clear that you are in no way connected with them. And if the customer still wants to use your
Yes, Lord.
services, well and good.
That is
That-
all.
That
Lord.
does not, it is not prevented here.
No, Lord,
This
what
is
has
the order
happened
which
is,
has been- What we read
Lord.
now is the order which has been affirmed.
no, no,
How are you agreed?
no, my Lord, the order that is affirmed, kindly permit me to just show the order impugned,
Hmm.
wherein, Lord, the order has been
Hmm.
affirmed. Now, please turn to Annexure A.
Hmm.
Page 24, Lord, is the order.
Hmm.
Now, can I request, Lord, please turn to the reasoning at page 29, Lord? May I read it?
Yes, please.
Since all these points require common discussion, they will be considered together for discussion in order to avoid repetition of facts. Admittedly, plaintiff has filed suit against defendants for the relief of permanent injunction restraining them from using their trade name phonetically similar to the trademark of the plaintiff, and also for mandatory injunction restraining defendants from supplying any infringing material in the course of their trade, and for such other relief. At the time of argument, learned counsel for the plaintiff clearly concedes that their main grievance with regard to annual maintenance contract obtained by their customers while selling their water purifier, Eureka Forbes, filled with the name Eureka Forbes. It is further contended that the defendants herein somehow secured the phone numbers of their customers, are frequently calling them and attending their service of water filter by using fake cartridges and other items while rendering the service to the customers of the plaintiff. And thereby his customers have been put into confusion, and in the guise of defendants servicing the water purifier are not only making money by using fake cartridges and other items pertaining to the water filter supplied by the plaintiff, also putting their health under risk. Learned counsel for defendants clearly concedes that they're not extending the service to the customer of the plaintiff
They are.
with regard to the service in the water filter supplied by the plaintiff. However, it is their contention that they are not using any fake cartridges or any other items which rendering such services, and rather they have been giving services by replacing the original cartridges or any other items as required, which were purchased by them from the plaintiff Eureka Forbes. Not have,
Is your contention?
Lord,
Is your contention? Yes.
Lord, I have said that, Lord, I provide services. Lord, I'm not saying I'm not providing services to the people who purchase AquaGuard. That is not my case. My case is, Lord, as a separate, Lord, entity, Lord, I am entitled to provide services.
Not been, you've
No,
not
Lord.
been restrained from,
No, Lord, the
you've
entire,
been restrained from doing that.
Lord,
If you say that you are a separate entity
true.
with a separate name which has no connection to the trade name or the trademark, you want to provide AMC to their customers, the customers don't want to take the AMC from Eureka Fob. Nothing stands in the way. Even now, it does not.
No, my lord, if I just continue reading this order, my lord, can I just page 31? However, it is not case of the defendant that they are authorized franchise service provider of plaintiff Eureka Forbes and thereby rendering their service to the customers of plaintiff. The business run by them in the name and style mentioned in the plain cost style Aqua Care, Eon, Sureka Forbes, Technovative Private Limited, etc. is not in dispute. It is not the case of the defendant that they are rendering service to the customer of the plaintiff with regard to the water purifier by mentioning they are from different company. That is defendant number 1, 2, 7 and 8 company. As long as defendants are neither authorized agents of the plaintiff having taken franchise of the plaintiff to render services of plaintiff with regard to the water purifier, question of defendants rendering such service to the plaintiff customer stating that they have purchased cartridges other items from the plaintiff, authorized dealer itself holds no water. This is the reasoning. Whether defendants have purchased cartridges and other items from the plaintiff or whether it is fake cartridge manufactured and used by the defendant's name of the plaintiff company are all matters to be considered time of trial. At present, it is not in dispute the defendants are extending their service to the plaintiff's customers and giving service to water filter Eureka Forbes manufactured by the plaintiff. As rightly conducted by the learned counsel of the plaintiff, if while rendering such service to the plaintiff customer, if defendant uses fake cartridges or similar cartridge with substandard quality, the purification of water may also be reduced by substandard, which directly affects the health of the plaintiff's customers. It is not the case of defendants. They have taken plaintiff franchise to extend annual maintenance service to plaintiff customers with regard to water purifier. In the absence of such contract between plaintiff and defendants, entertaining defendants' contention amounts to allowing them to enrich themselves at the cost of the plaintiff business and general public health at large. This circumstance establishes an irreparable injury that may be caused to the plaintiff hearing and the public at large. The plaintiff person who seeks equity must do equity. The defendants are required to perform their business in accordance with law and force. Plaintiffs have also produced certain documents like FIR registered against defendants for attending the service of their clients in the name of the plaintiff company. Such attitude of the defendant requires to be nipped at bud. Prima facie, plaintiff has established his case for grant of an order of temporary injunction against the defendant. Balance of convenience still in favor of the plaintiff who are spending crores of rupees towards expenditure on advertising their products, who have developed reputation in the society in respect of the products manufactured by them, including Eureka Forbes water filter. Accordingly, I have answered the point in positive. But therefore, the reason of the trial court is, and even their argument before the trial court is, you are providing service to my customers. You are not providing proper quality cartridges, etc. Due to which the customer is getting affected. But if the customer is getting affected, not the customer has to take action. Number insofar as I am concerned, I'm not representing Sureka Forbes or not defendant number 8.
Therefore, IA number filed by plaintiff under order 39, rule 1 and 2 is allowed. IA 11 and 17 filed by defendant 1 to 3 is dismissed.
Yes.
The results in the result interim order granted
Made
by
absolute.
this court under IA number 1 is made absolute.
Absolute.
What has been made absolute is only this, that you cannot carry out the AMCs in their name. That is all there is to it.
Not AMC, not insofar as not I provide AMC.
Here, what is stated is, hence defendants, their proprietors or partners, officers, servants, etc., are restrained by an order of injunction from using the trademarks, Sureka Forbes, Aquacare, Iron, etc., it's a Forbes Technovative, so and so private limited, which are similar to that of the plaintiffs, registered trademarks till the next date of hearing. Plaintiff has also made out sufficient grounds for appointing, etc., etc.
Not if not, please see not paragraph 5, that is the order at page 89. Lord, the last 3 sentences, defendants, their proprietors or partners, officers, servants are restrained by an order of injunction from using the trademarks Sureka Forbes Limited, but I have no grievance with that. Aquacare, Eon Exchange, but I have no grievance with that. Then not Forbes Technovative Private Limited, but I have grievance with that because I represent them. Then Eon Exchange Private Limited, which is similar to plaintiff registered trademark. Not how is not Forbes Technovative and Eon Exchange Private Limited not similar to that of the plaintiff's trademark? My trademark is completely different. Lord, kindly see, Lord, what is registered, Lord, in their favor. Now, Lord, it becomes important to point out, Lord, that their trademark, Lord, please turn to annexure R2 of their objection that they filed before Lords at page 26.
Yes,
Lord, if my Lords may kindly see the date, Lord, of the certificate is 5/1/2021. My Lords have it, Lord,
yes.
the top middle portion. And Lord, on the left-hand side bottom, it is 3rd of June 2021 is a date. When the certificate, Lord, under Trademarks Act is issued.
Yes.
Then, Lord, on the next page, that is page 28, Lord, so please turn to, I'm sorry, 27, Lord, is their trademark, Lord. Eureka Forbes Friends for Life. This is what is registered.
Water purifiers, filters for water purifiers.
That's
electric
goods
water
description.
Electric filters.
Please.
Apparatus relating to water purification.
Yes.
Water treatments, etc., etc.
Yes, no.
Yes.
But not the logo or the trademark is only not this Forbes, Eureka Forbes Friends for Life. Then page 28, if my Lords will please turn to. Lord, this is not the registration of under Copyrights Act, page 28. Lord, this is dated 27/5/2014 on the right-hand side, not to get it at the top. Then, Lord, the class and description of work, Lord, is artistic work. And the title of the work is Eureka Forbes, Your Friend for Life with logo. But this is what is registered. Page 29, Lord, is the copyright.
Forbes is also registered.
Yes, ma'am.
Eureka Forbes, yes.
Forbes.
Yes.
Just Forbes is also registered.
Yes.
The name Forbes is registered. For microwave ovens, refrigerator, water purifier, air conditioner, electric water heater, chimney, etc., etc., etc. Cooking appliances, lamps of all kinds, whatever. Forbes is registered. Yes.
But I am given to understand that Forbes, they have recently registered even the word Forbes. That's what subsequently they have registered.
But are you ready to?
I only wanted to be
Lord,
one thing,
there's
Lord.
one submission before my learned friend
Yes,
commences.
just a.
Lord, the Lord, the question would be, Lord, whether, Lord, they can club the issue with regard to copyright and trademark simultaneously same suit. Lord, the apex court, Lord, in case of Dabur India, had an occasion to deal with this. Lords, may please turn to Lord para 30.
What is the stage of the suit now?
My lord, issues will have to be framed. They have violated injunction order passed by the trial court, my lord. There are 4 miscellaneous matters pending as against them, 2 against them, 2 against the other 2. That is separated, my lord. That's a separate petition which is going on. Framing of issues, my lord, the matter is pending at.
Yes.
Lord, if my Lords, please turn to para 30, Lord. 30.
Yes.
If a person is found to be guilty of violation of copyright, he'll be bound to pay damages. For the purpose of quantification of the damages, taking to the accounts may be necessary, and it is in this behalf Parliament thought it fit to use the word otherwise. Thus, power conferred by law within the meaning of subsection 1 of section 50 of the 1957 Act qualifies the power of the court to grant remedies as envisaged thereunder, if any other cause of action arise under different act. An action for passing off is common law right, but the same does not determine the jurisdiction of the court. For exercising such jurisdiction, the provisions of the court would be applicable. 1957 Act being a special law would thus prevail over the general law of the court. Then Lord para 34. That when then would be meant by composite suit. My Lords have it, no? Para 34.
Yes.
What then would be meant by a composite suit? A composite suit would not entitle the court to entertain a suit in respect whereof it has no jurisdiction, territory, or otherwise. Order 2, Rule 3 of the court specifically states so, and thus there is no reason as to why the same should be ignored. A composite suit within the provisions of 1957 Act as considered Doda House, therefore would mean the suit which is founded on infringement of copyright and wherein the incident power of the court is required to be invoked. A plaintiff may seek a remedy which can otherwise be granted by the court. It was that aspect of the matter is not being considered by Doda House. But it is never meant that two suits having different causes of action can be clubbed together as a composite suit. Now, my lord, violation of the trademark would be independent, violation of the copyright would be independent. Now, they have clubbed both of it together and filed a common suit. Can I just not also request not the documents which not we have also produced to show that not the nature of work that I have carried on, not in fact not I have purchased materials from them. There are invoices which they have also produced along with the objections here. But I have purchased materials from them.
Filters.
Can I just not request not please see the filters, not? Not both these filters not are manufactured by a different company. They purchase it not from that company, so do I. I don't use not their name.
Depth filtration.
Yes, not. But I don't use their name for the purpose of not giving it not to customers.
Apparently is a different product altogether.
Yes.
It
No,
is a
but-
different product.
But it is manufactured by the same company.
Maybe
But
the product appears to be
In fact, my lord,
different. In normal situations, the question would be whether you are using their name and passing off as their,
yes,
that would be the question.
not the right note. Therefore, not they'll have to point out not how. Not,
Breaker Forbes, your friend for life. This is available as packed for you, Eureka Forbes to you also?
but yes, Lord, I can purchase not from not this depth infiltration technologies, not with their name, not with the name of Eureka Forbes.
But this does have the name of Eureka Forbes.
Yes, Lord, I've given Lord two different sets. One set Lord will not contain the name, one set will contain the name. I think Lord, His Lordship has not the other set.
all these things will aid in my benefit.
Just a- Consider as overall, would if somebody
Lord.
comes in,
My brand name is Hygiene.
your claims, if you do from parts of the product, wouldn't it be- Hmm. Is available at 40%. Why would I keep people there not for that?
That's all right. What else?
Raised dealers.
But
No, exactly. These are matters which will have to be considered in the suit. Because if this is one case where we ourselves would be able to, maybe probably talk about. If a person comes to you and says that we'll do your AMC for you for the AquaGuard filter at apparently a higher price.
please, Lord.
Because the AquaGuard original filter costs $475 and yours appears to cost $499. Why would anybody in the normal circumstances say that you and I,
Yes.
why would anybody take it from somebody else unless it is, there is some kind of a representation that there is an authorized AMC
Lord, it-
involved?
Lord,
Why
it-
else?
Lord, I would submit this way, Lord. When Lord,
Normal situations, the court would not be able to consider any of this. We are just asking you because we are all customers, people who use these products.
room, Lord,
So,
AMC that is entered into, Lord, I do not know what rate, Lord, it will be provided for to the customer, but I can verify and make a submission. But the fact remains, Lord, the customer, Lord, enters into, Lord, AMC with me. Lord, that cannot be found fault with, Lord, by the respondent solely because the product, that original product, is sold by them. Now, Lord, they don't manufacture these, Lord, candles. This is purchased by them as well. Lord, I also purchased from this very same person, and I provide it to them. Lord, the reasoning of the trial court is, Lord, the public health will suffer. Lord, the question is if a customer, Lord, feels that not I have provided a substandard material.
Why we wanted to know what exactly was your case before the.
Yes, Lord. So can I just not request Lord to please turn to not the documents, not which not of course there are not this. I've prepared an application also to produce some additional documents. Lord's permit, not I'll pass on that as well.
Well, that is beyond us at this stage of the proceedings. We are only considering whether that order was justified or not. Till there are two things we could do. We could ask the commercial court to expedite the proceedings and finalize it in a time frame.
But my entire business has come to a standstill. Now, Lord, what has happened is, by virtue of the order, there's a seizure, etc. In fact, insofar as Lord, my instructions are that Lord, we were asked to surrender Lord the all hard disk, etc. Everything Lord has been Lord given to the court is what I'm told. But therefore, Lord, I'm not in a position to carry on business because of Lord this order. But insofar as Sureka Forbes is concerned, Lord, I understand Lord Eureka and Sureka Lord, they're quite similar. But therefore, Lord, I have of course, Lord, we have nothing to do with them. But Lord, that may be a different aspect. But insofar as I am concerned, Lord, please see the name of the company. Please see the name, Lord, in which Lord I've issued bills. Lord, the bills also reflect the name, Lord, of appellant number 2, appellant number 4, Lord. Eon Exens. Lord, how would that be similar to Lord that of the plaintiff?
Now, what was your written statement?
Lord, my written
Had you placed pleadings on record? Written statement was on record?
Yes.
Whatever was canvassed before my lords, none of it has been taken. As the
Exactly
written
what I
statement.
wanted to know what the.
And in case, my lord, at
There is
page
written statement.
71, I will read out, my lord. This company, so-called Forbes Technology Private Limited, I will read out at page 71, my lord. The defendant number 5, that is Forbes, is preparing, defendant number 5 is, my lord, Anand Naik. There are two culprits, my lord, Anand Naik and, my lord, and Balaji Kumar, who were related, my lord. Initially, they started this ion existence. And, my lord, the losses which they're causing to the plaintiff company, it runs in hundreds of crores. In fact, these filters might come to our aid, my lord. I am surprised that name Eureka Forbes is found on something as they themselves are bringing more evidence in our favor. My lord, I will read out this. The defendant number 5 is preparing to launch Forbes Technology Private Limited. They're preparing to launch. This is the written statement filed in 2022. But still, this Forbes Technology Private Limited company is kept pending to launch the market because the trademark copyright license was not obtained from the concerned authority. In fact, my lord, the trademark application was rejected. And my lord, that is at page number 167. Objections, my lord, 167.
Your objections.
Yeah, my objection. Statement of objection. For class number 11, R16 is the annexion. Forbes Technology Private Limited, it is refused.
Oh, they had sought for Aqua Care. Aqua Care as a trade.
What they're doing, my lord, we have about 13 registered trademarks and about 7 copyrights also, my lord. And they gain entry to the house of the customers of the plaintiff. They portray themselves claiming to be, they are the service agent of the plaintiff petitioner, respondent company. And my lord, they're installing fake parts. They are manufacturing these parts because we do not know where that manufacturing is happening. They are also, I don't know where they've obtained this. They're also obtaining these kind of filters from third-party market, which is all counterfeit products in the market. And
where does it show that it has been rejected?
My lord, page number 167, my lord. It's class application number 4771463, conflicting mark, Forbes Technology Limited. My lord, the status, it says refused. In 2020, this
Just a moment. Where is the status?
R16, my lord.
Yes, status.
Yes, my lord. Status says it's refused.
Yes.
In 2020 itself, it was refused. And their claim is, I have not even launched this product in the market. And there are invoices, my lord, in the name of Forbes Technology, where in the contempt petition, what I filed before the commercial court, my lord, I've produced all of this. It's marked as exhibits. At one hand, they say, okay, this company, we're not even doing business. And they make a false statement in the written statement that they're in the process of obtaining trademark. In 2020, 2 years prior to this written statement, it was rejected. It has been refused. None of it is brought to the court's notice. And
14/10, use the date is 14/10/2013. When is
date
the
of application, my lord, there is
8 12 2020?
Written statement is filed in 2022. And this is just the tip of the iceberg in terms of the bundle of lies both the parties have presented before the court, my lord. And they gain entry saying that they are from Eureka Forbes. In fact, they have customer database because he was a former employee that we realized a little later in the day after filing the written statement. He knows most of the franchisee business partners. My lord, what happens is earlier it was all manual books, my lord. Customers' names were maintained in records. They have managed to take those initially. This business they started in 2013 or 14, those were initial days. Subsequently, my lord, customer database is stolen on a day-to-day basis. My lord, I have AMCs with my customers, my lord. 1 year, 2 year, 3 years is the term. When from our customer call center, if a call goes to our customer to say that we are coming to renew or coming to replace your filters, even before we approach, they send their workforce and they gain entry. And my lord, the cards, everything, their ID cards, most of it's all bluish in color, which is again, color also represents an important aspect in trademark, my lord. So they gain entry, and my lord, the service, it's only after few months when the products are not working because it can never match, my lord. And what was produced shown before the court, that is not even shown before the court. These are the filters which are produced before the trial court, my lord. It has the scopes. They can't be doing in the name business in the name of Forbes. This is the same mark in which, my lord, the application at page 167. My lord, one is original Eureka Forbes, my lord, that is again Forbes. So their application is rejected, yet they're doing business in the same logo and name.
This Sureka or?
In fact, my lord, R18 may kindly be seen. They issued an invoice in 2022. This is, my lord, again, one of our customers complained saying that, look, the products are not working well. And once we visited, then we collected the data. This is the invoice at page number 169, 2 pages later. Forbes Technovative Private Limited. And they are issuing AMCs. 17/5/2022, after the injunction order. And my lord, these are only 2-3 instances. Out of 1,000 customers, my lord, not even 5 are willing to come before the court. Hardly 10 people have given their, either they've given the filters or they've given these invoices given by the petitioner here, applicant here.
Yes.
Words. The instructions are not, this relates to Sureka Forbes, not the cartridge which not my client supplies, but not be that as it may. Lord, can I request, Lord, please turn to Lord page 172 of the objections which my learned friend has filed. Page 172, annexure R19.
Yes.
Not Forbes Technovative Private Limited, not is a bill. Not I have not used the name, not AquaCare, AquaGuard, or whatever not is registered in their name. But please turn to the next page as well. Page 174 not is I'm sorry, it's a better copy.
Yes.
But there is no reflection of not anything related to them.
You don't deny this.
Please not.
You don't deny this.
Well, I'm just pointing out what document that they have produced. Not,
Yes.
but I'm even not, my client says not they even ready not to close the business in the name of not Forbes Technovative, not that is what not is troubling not the plaintiff. I'm ready to close it down. And not I will not use the names not which they say not Forbes or AquaCare or AquaGuard. I will not use it.
As far as if that is the what you're holding out, then there is no issue at all because that is all that you've been
Now,
injuncted from doing.
Now, what has happened is my difficulty is not all the entire data is now surrendered to the court. And not the injunction is not only against not the company.
You can
Even-
settle it.
Please not.
You can settle it if you agree, if you undertake not to use their names or to pass off as their service agents, they probably will not have any problem with that.
No, their grievance is also that I'm providing service, not AMC, not to their customers. No, that is their main grievance. Not.
It's not that you, as an independent organization, go there and say that I have nothing to do with these people. I am offering annual maintenance. I'll do it cheaper. And if anybody wants to do it, they probably will have nothing to, no problem with that.
That is
That
their
not
main
the issue.
grievance.
That is not the issue. The issue would be that you are attempting to get the annual maintenance contracts as them or their authorized agents. That would be the issue. So
Not-
therefore, if you're willing to settle this out of court, we will not stand in the way.
No, I'm not saying
Otherwise,
settling.
we'll have to await the.
So rampant,
But
Lord, for
my-
the last 10 years,
Hmm.
year on year, at least 80 to 100 crore admitted by the different appellant number 2. He himself says he's caused losses to the tune of 150 crores to us. And my lord, when this matter, this commercial appeal was pending, the plaintiff's representative is one Dinesh. He himself gets a call. If I may be permitted to play this audio clip, my lord, that clearly established in trial court also we filed about 7 or 8 from the call center. As and when the matters are happening, this is despite an injunction order. My lord, no court is preventing, like they have no respect for both orders. They have no respect for law and order. They continue to do the business even till date. And so far as those hard disks, whatever they claim, they have submitted, my lord, he himself claims that everything is saved in a cloud data. And replicating from cloud to, my lord, a hard disk, it's a matter of 2 hours. In fact, initially, my lord, court, the honorable trial court, my lord, only said, seize those hard disks because your customer data has to be protected. That endeavor, my lord, both the respondent, all the defendants in the suit, my lord, they basically refused to even part those hard disks, and the warrant which was issued by the trial court, my lord, it was not at all complied with. On a subsequent date, because it's a matter of half an hour, they can delete all the data and then surrender a hard disk. And Lord, what happened was the date on which the ex parte order was passed, and then when the court commissioners went and tried to seize only the hard disk, not the filters, nothing else. They refused. They did not permit them to even touch those hard disks. And at a later date, about
was Sureka.
15 days later, they said we will surrender these hard disks. And my lord, the court commissioners have taken those hard disks, my lord, given by Sureka Forbes, that they've conducted investigation. The report clearly says that it's been tampered from the date on which passing of the interim order till to the date of submission. And so far as their hard disk, my lord, they had submitted about 10 or 12 hard disks wrapped in a plastic paper. Court commissioners refused to take it, saying that this has electrostatic energy and magnets, and then the moment you wrap it in plastic, the hard disk is bound to corrupt. Ask them to submit it properly. And my lord, subsequently 2 hearings, they did not submit, my lord, the hard disk. Second time the warrant was issued against them, that is when other 14 hard disks, according to them, my lord, the hard disk was before the court. They could not operate. Second time when the raid was conducted, my lord, another 12 hard disks were seized.
But
Yes,
can I just make one request, Lord? Not the interim order is granted not only against not the company, but also against individuals. Lord, I cannot be prevented from carrying on any business as such. Now, Lord, my submission to Lord is insofar as these two, the company that is Forbes Technovative, Lord, my client Lord states that Lord, he will not carry on business in that name at all. If that is so, Lord, then Lord, I can file an affidavit before the court. If
please-
that is
please
so,
place it before them. If they're agreeable, we'll
but it,
consider.
Lord, of course, Lord, they will not be agreeable to it because Lord,
Drop of a hat, my
No,
lord.
we are not saying anything on the merits of the matter. We are only saying that this, anything further is to be considered in the suit.
please, Lord.
That anything further with regard to this, unless you come to some kind of a settlement out of court, which we will not stand in the way of. Otherwise, it will have to be considered in the suit. We'll even direct an expedition of the suit.
Lord, the legal contention with regard to Lord, trademarks and copyright,
Open.
Lord.
We'll leave it open. That has to be considered in the.
In the meanwhile, Lord,
proceedings.
my entire business has come to a standstill.
Not
Lord,
to-
therefore, Lord, my submission to my lords is, Lord, their grievance is basically against Sureka Forbes. But insofar as Lord Forbes Technovative is concerned, Lord,
Does not appear to.
but Lord, the trial court order, Lord, says only because I'm providing AMC, Lord, to the customers, Lord, of the plaintiff, Lord, there is difficulty. Now, Lord, mere providing service, not to a customer, be it not their customer or somebody else's customer, but that would
Yes.
not come in the way.
If you were to walk into a house and say, we have nothing to do with Aquacare or with the company, Eureka Forbes. We are independent people. Let us do your AMC. And if you get an AMC, well and good. We fail
That
to
also
see
not
how
now.
that- We fail to see how that would be possible.
I'm not, if not I provide, if I provide not as I pointed out not, I may buy a car from anywhere, but not I can provide for service anywhere. I can provide it outside. I need not, but when I have a not warranty period,
That
but
is-
I'll go not to
is
that
an
company
informed
itself.
Decision made by the customer.
True, Lord.
It has to be an.
I bought on
informed
to what
decision.
Lord is saying.
Release it.
Same way, Lord, here also,
Yes.
FIR, my lord, which is registered by the customer at annexure R25, page 192. I will read out the elements of the complaint, my lord, at page 193. I'm writing to report a case of fraud that have recently become a victim of a person named,
Yes, yes, yes,
yes,
yes.
impersonated to be Eureka Forbes employee, called my wife and inquired about the services I need. To which my wife said yes, and the person, photo ID attached, visited and changed the candles of the purifier and sold an AMC for 2 years, costing 8,800. So it's about 8,000 to 12,000 what they are charging under our name, saying that your AMC got over. He
Where is the
also said that
complaint?
he would send receipt later online because they were caught, my lord, after filing of the suit. This is 2023. My lord. They had all my details, including my proper address, product details, etc. My wife made the payment using UPI screenshot attached. I already have Eureka Forbes AMC till 2024,
Yes,
which I told my wife later when I checked online. I also the taste of the water felt a little bad, so I called Ranjini and Rakesh multiple times. I'm following up with Ranjini and the person named Rakesh for the last four days, but they're not returning my money. Every day they say they would return the money today, but they're not doing that. To me, it seems it's a big fraud case. These group is doing with many people. I called Eureka Forbes after that incident, and they confirmed that these guys are not from their team.
Lord,
Yes.
The Eureka
Lord,
Forbes
my
company
instructions
even
are not,
confirmed the candles installed by Rakesh is duplicate / local one. So I got that replaced with original one as part of my regular AMC from Eureka. This is another problem a lot. After having installed original parts, they come and replace fake parts. We are now obligated to replace these parts. The losses which the company is suffering, my lord,
Lord,
it's
my instructions are
700
not,
crores.
we have filed complaint not as against these people. They're employees of Sureka Forbes, not my employees, but they've used not the name, not my company. I have filed a complaint not before the police in this regard.
yes.
But can I make one request? Not, I'm sorry, not just one indulgence. Not at least insofar as not individuals are concerned. Not if the order not is but modified, at least not I'll be able to carry on some business.
We'll consider.
Not without reference to not without using their name, not may not put me to terms, saying that not I will not use the name of not Eureka Forbes, not or Aqua, I'm not sure, or whatever, not for which not they're registered.
Yes, reserved.
Grateful.
Much.
This is, commercial appeal under section 37, the Arbitration Act.
Yes.
And this, your lordships have called for the records.
Records are
Cons-
here. Can we hear
records
it
have-
today? Are both sides ready? Can it be heard today
I am ready.
after 2:30?
2:30, I
Okay.
may have 2:30
2:30, yeah.
serious cases here. Important.
Today,
And it is not, then your lordship may kindly,
11:23.
correct, then your lordship may kindly have it on fifth
On
or
the
sixth,
date?
fifth or sixth, your lordship may kindly have it.
5th,
Fifth or
5th of
sixth.
August?
Yes,
Yes.
interim order may kindly be extended.
Both parties.
Poor farmers asked the.
Allah,
Small,
everyone is saying
10
poor
years,
farm.
10 years, both the arbitral court as well as the commercial court. has-
We'll consider section 37,
Yes.
the window for consideration is, you're aware of the window.
Yes.
We'll consider.
Yes,
Yes.
please, interim order may kindly be extended.
We are ready for arguing the matter on the 5th of August. The records are here. Listed on the 5th of August.
The interim order may kindly be.
Yes, interim order
Please.
shall remain enforced till then.
Basic question to be considered is, if the non-compliance of 69 to the Partnership Act, what is the effect?
Yes,
Basically. What's the effect?
My lord, before
yes.
sir continues, I was on caveat till today, I have not even been furnished with a copy of the petition.
Please see that copies are provided. We have to hear him as well. There is a caveat. Yes, learned counsel for the appellant shall make available copies of the appeal as well as all interim applications to the learned counsel appearing for the caveat or respondent. This next week.
They will furnish it during the course of this week. In
Yes.
the meantime, the other side has sent execution petition. So either undertaking or.
When is it listed? When is the execution petition posted?
Next month. Money,
1/8. 1/8 is,
After tomorrow.
still next.
you've just filed it, it's just coming up.
Yes, my lord, even over there, the court is saying await high court orders.
Don't precipitate
I
the
will
matter.
not do it.
Yes, list after a week, not the fifth, the week after, week after. Yes, 12/8
Please.
till such time. The further steps in execution shall not be precipitated. Till the next date. Don't precipitate it till the next date.
Please, till the next date I will know.
Yes. Section 8 rejected.
Section 8 has been rejected.
Sorry.
You've been served with copies of the
Yes.
objections?
Sir,
Can we have it? on-
objections, my lords, they have not.
Can we have this?
It would be, my lords, but the matter before the trial court is posted on 5th of August.
We'll have it on day after tomorrow,
Yes, that's absolutely,
day after.
not 31st, first of, please. Please.
First, I have some difficulty, my lords, may have it on second, I apologize, my lords. Second.
Grateful,
Grateful.
grateful.
Please, your lord.
I appeal, may I please your lordship, I appeal for the appellant. It's a defendant's appeal, my lord. I have filed the application before the trial court under section 8, my lord, which came to be rejected. Therefore, my lord,
Now the
this appeal has
19th
been
appearance,
filed.
thing of it, first time.
Yes.
Now, need time to file.
My lord, I may be permitted to make few submissions. The reason for which my application under section 8 was being rejected.
Can we await the objections and have it on a near date?
No, my lord, the matter is coming up on the 29th, my lord, today, my lord, the matter is listed.
For?
Listed for evidence, my lord.
I am the plaintiff.
My lord,
before
I
the trial
have
court, ma'am.
sought for the interim order to stay the further proceedings in the commercial original suit, my lords.
My lord, there's no
Only on the-
urgency in the matter. The section 8 application relates to another agreement and the trial court has duly considered and dismissed it. The evidence can go on in the matters listed today as well. We'll file our objections and lead arguments.
No, my lord, in this case, my lord,
Let the, if you're seeking time to
interim
file
order may
objection,
be,
let the trial be postponed till,
That's my only contention here is I'll just give a brief background, my lord, what is involved here. There are two agreements.
pass
that-
over. Hear you, please.
for the appellant, my lord, kindly pray for time
Pray for time for what?
for producing
Giving
this.
arguments.
Yes, ma'am.
Enhancement is challenged.
Yes, ma'am.
Notice has to go. Notice has to go. Does not notice have to go?
It is for stay, my lord.
Learned counsel for the appellant seeks time list after 2 weeks.
Appear for the appellant in this matter.
Yes,
Appeal under section 37 of the Arbitration Act, my lord. Section 34 filed by the appellant petitioner is came to be dismissed by the Honorable District Judge Court. The fact of the matter is that, my lord, for the
Yes.
formation of national highway, at an extent of land of the respondent number 3,
Hmm.
respondent number 1 is acquired.
Hmm.
That is measuring 607 square meters and 405 square meters.
Hmm.
According, that is in survey number 13/23
Hmm.
and 13/1B2.
Hmm.
Initially, respond number 1,
Hmm.
respond number 2 passes a general award,
Hmm.
determine the compensation for the entire village.
Hmm.
Accordingly, including this respond number 1 property also, compensation has been determined.
Hmm.
Amounting to rupees 13,274 per cent.
Hmm.
13,274 per cent, my lord. For the both the
Where is the
acquired
property?
properties in Mangalore, my lord, Dakshina Kannada district. What has happened, my lord? After that, as per section 3G5 of the National Highways Act, there is a provision to file appeal that aggrieved party files appeal before the statutory arbitrator, who is the respondent number 3 here in my lord,
Yes,
deputy commissioner. Each district has arbitrator who is the deciding authority. He announces the compensation that your lordship will get at page number 47 of my appeal. 47, table is there.
yes,
That column number 4, my lord, 1, 2, 3, 4. That is the amount determined by the Honorable DC, my lord.
Hmm.
That column number 3 is the 13,274 and for both the properties.
Hmm.
Then last line, that fourth line, 2,60,726. As far as the appeal is concerned,
Ordered by the second respondent was the same rate for commercially converted land and wetland.
but during that period, he has not produced any document to show that property is converted. As per the survey record and revenue record, it shows that it is a agriculture land. Accordingly, he decided.
See the table. It appears that horticulture, forest, solatium, land value as per factor.
Yes, here one more submission, my lord. As far as 328 square meter is concerned, there is no dispute. We have paid that compensation.
Hmm.
Now, only dispute under this appeal is that, my lord, 607 square meter,
Hmm.
that 2,60,726 is decided. Actually, as per the average annual value, amount comes to 2,10,000. If it is commercial rate, it is comes to 2,10,000.
Yes.
282. But instead of deciding that amount, he paid again 2,60,000. That is the only under challenge. Now, lordship may kindly see, before the district judge court, during the pendency of the appeal under section 34, we agreed to make the payment of 2,10,000. We paid also that amount to 1 crore 36,278,000.
That has been paid.
Yes, sir, that has been paid. That art sheet also there. He received also. We filed a memo before the trial court saying that as far as the commercial rate is concerned, we are ready to pay. Since he has not produced the commercial document, we could not pay. We paid also. That next page is the voucher, my lord. He received also. As per the directions of the Honorable District Judge Court, we have paid directly to the party, to the respondent number 1. Now, disputed amount is after deduction around
Only 1,55,054. That is.
no,
all
1
it will
crore,
come to.
1 crore,
Where? Oh, yes, I'm sorry.
1 crore 34
Yes.
lakhs paid, my lord.
Crore 24 lakhs, 14,380. Yes.
That amount has been paid, my lord. 1,36 paid. Lordship may kindly see one amount recommended for payment as per rate fixed by the defendant number 2, 1,36 lakhs 29,770. Now only is 34,880. As per the calculation of DC's NSCOM, it will come to 1,71 lakhs. But we paid 1,36 lakhs. It was not considered
Only with regard to that.
34
portion
lakhs.
that-
Yeah, only for that reason.
Let's admit. Belonging counsel for the appellant, admit issue notice to the respondent. Third belonging counsel for the appellant who contends that the entire admitted compensation taking note of the commercial value of the lands concerned has already been paid and voucher for payment of the enhanced compensation had been made available before the trial court on 29/10/2020. The above view of the matter, there will be a stay of further proceedings pursuant to the
Execution of the award.
stay of further proceedings in execution of the impugned award till the next date of hearing.
Yes, ma'am. Great.
That is the order is in the IE. The appeal. notice.
Appear for the,
Yes,
on the last date of hearing, there was an order passed by the court to secure the lower court record.
secure the records. Oops. Records have been produced. Are the records here? Yes. Yes, we'll have to await the records because it appears that it was in whose name was the revenue, the entry in the records in your father's name. Initially.
All through, initially my grandfather's name,
Hmm.
subsequently my father's name, and subsequently our name came to be entered in the revenue records.
Your name was not found in the revenue records, appears to be
That is
the
my father's name, my
one, sir.
my father's.
Yes, let the records also come. Anyway, it is listed for that purpose. Learned government advocate seeks a week's further time to see that the records are produced. List on 6, 7, 8. Yes.
In this case, we are using OM alert, subsequent filed appeal. The respondent have filed our part in official memorandum stating that they have not acquired the land and they have utilized the land without paying any compensation to us. And thereafter, they have issued an OM allotting 50% of the land to us in a different way. But till now, OM has been done. Allotment letter has not given to our hand.
Alternate land. Is it alternate land that
The
has?
alternative land.
Alternate.
Now, I'll just, the translation like, but my lord, my colleague have handed over today morning only. Therefore, I am unable to get it translated. So in the meantime, I'll get a translated copy, the last, and the government will get.
Let's get instructions on this. I'll take the instructions. Yes. Memo accepted on record. The learned counsel for the learned government advocate seeks time to get instructions in the matter. List next week.
Lord, in the meantime, they found that after verification, Lord, let there be a direction, oral direction, at least to issue allotment letter in pursuance to that OM, Lord. It is dated 20.
You are before the court.
Yes.
Why do you seek allotment letter from them? If that is so, we'll let us see. Yes.
Lord, in the memo filed today, memo have been filed first, index is subsequently stitching. There is error. I'll correct it now itself.
Please. The
Not appear for the,
KSAT correction of date of birth.
yes, my lord. Now, my lord, the correct date of birth is not in dispute. In the corporation records also correct date of birth is entered.
That
To
is
get
not
it
the issue.
admission, my lord, with.
Whether it can be corrected in the service records is the issue.
After 20 years.
What
My
is
lord,
the
my lord,
provision?
The question is, my lord,
What is the provision with regard to correction in the service records?
my lord, the Karnataka State Servant Determination of Age Act 1974.
That is with regard to the determination of the age.
Yes, my lord.
That may not be the provision. The provision probably is in the KCSR.
No, no, my lord.
There is a
Same.
provision.
No provision. In this only, this act only. My lord, what they say, they are saying is, my lord, correct date of birth is, my lord, 12/3/1969. It was wrongly entered as 12/2/1968.
Hmm.
To get it admission in the school, my lord. Maybe after death of my father, my mother has did it. Now the question is this, my lord. Now it is not the fag end of the year. I will not, I will retire in the year 2029. Another 5 years is there.
When did you enter service?
My lord,
When did you enter service?
91, my lord, 3/12/1991.
3/12/1991.
Joining service on 5/12/91.
5/12.
5/12/1991, my lord.
Therefore, you were aware that there was a mistake. When was the, was
In the
there
year
any-
2020, my lord, in the year 2020, when I collected the information from my grandmother, she said, "Ma, this is the position." And my lord, the endorsement issued by the respondents.
Hmm.
Lord, can you take, my lord, page 49?
No, what is the finding of the tribunal?
My lord, the finding is at page 21, my lord.
Can be exercised as per the Karnataka State Government Service
Yes,
Determination
madam.
Age Act 1974.
At page 21,
Applicant's
bottom.
request is not in accordance with the provisions of the Act 1974, the application deserves to be dismissed.
Page 22, the reasoning is, my lord, the main reason. Even if there is a cogent evidence, the same cannot be claimed as a matter of right. Application can be rejected on the ground of delay and latches. Also, more particularly when it is made at the fag end of service. But that is not the case here.
Delay in latches of 12, of all these years.
My lord,
19 years.
1991, why did
My
you
lord, the
not,
question is, my
take
lord.
this up?
my lord, in the year 2020, I noticed it. I brought to the notice of the authorities. My lord, kindly section 3(2), my lord. Section 3(2), the
Hmm.
duty of the
Hmm,
my lord, employer.
hmm.
3(2) nulli.
Just a minute.
Determination of age. Determination of age. 1976.
Second act. Yes, 3(2).
3(2), my lord. Well, section 3, determination of age and entry into services, entry into state services. Every person on appointment
Hmm.
as a state servant shall declare his age along with the date of birth, and in support of such declaration shall furnish to the appointing authority documentary evidence, namely an authenticated extract from the birth or baptismal register, original horoscope or correspondence contemporaneous with the time of birth, indicating that the date and time of birth, an authorized copy or extract from the entries made in the school or college records indicating the date of birth, provided that where any such document is not available, the reasons for its non-availability shall be furnished along with such other documentary evidence in support of the declaration of age and date of birth as the appointing authority may require. The appointing authority shall, notwithstanding anything contained in any judgment, decree or order of any court,
Hmm.
after considering the evidence produced by the state servant, under after such inquiry as it deems fit, accept the age and date of birth which in its opinion is satisfactorily established, and shall inform the state servant, and shall record or cause to be recorded in the service register or book or any other record of service of the state servant, the age and date of birth so accepted. In my case,
Do you have a case that you don't have a service register?
but service register, my lord, if they accepted my date of birth as, my lord, the original date of birth 12/2/1968, they have not, they should have informed me after conducting inquiry.
That's not what 3(2) says. 3(2) says you shall declare your date of birth. That should be supported by documents. If the documents are not available, then you should say so to the authority. The authority shall consider and record in the service book the date of birth which the authority thinks is the, after such inquiry, accept the age and date of birth as provided by you, which in its opinions is satisfactorily established, and shall inform the state servant, which means the initial entry, not the correction.
Initial stage,
Initial entry, not the correction.
initial entry, my lord. This is initial entry.
That if,
Now, in this case, initial entry, my lord.
Yes.
Section 3(2) pertains to initial entry.
Hmm.
Initial entry.
Hmm.
Now, my lord,
is it your case that you don't have a service register at all?
please, my lord.
Is it your case that you did not have a service book or a service register at all?
Service register was there.
Was there?
It was there.
It has to be periodically signed by you.
My lord,
Have you not done it?
after completion of the probation period,
Hmm.
they have passed the order.
Hmm.
At that point of time, my lord, this issue was not raised. That means they are not, at the completion
Why
of,
does it have to be raised?
my lord, this,
Your service register requires your signature.
yes, my lord, yes, ma'am.
Isn't it?
No, they have to
Could it not
inform
look at
me,
the-
but the authorities have not informed me whether they have accepted this date of birth.
Shall I ask them to produce your service register? And if it is found that you have, as a matter of fact, signed on it, will you pay costs,
My lord, one more,
compensatory costs?
no, one more.
Have to be signed by you, council.
I signed the service register, my lord.
That is
Now,
the end of the
the
matter.
question is, my lord, at the
Yes.
fag end of the service,
Hmm.
the application is not filed.
Hmm.
It is filed, my lord, immediately, my lord, after I came to know that it has been wrongly entered.
Yes, which is the order rejection?
Rejection is at page annexure A, my lord. Kindly see the reasons, my lord.
Yes,
Para 7,
yes.
para 6, my lord.
Page,
Page, my lord, 20, it starts on page 6. And the reasons assigned, para 7, my lord, they followed the judgment.
no, that is the order of the tribunal. We are asking you about the order by which your request was rejected.
Page 49, my lord.
What does-
Translated copy.
What does it say?
It says, my lord, page 15 only. Without permission, my last operative portion, on examination of the same, sub-rule 2 of rule 5 of the Karnataka State Service Servants Determination Wage Act 1974. No such alteration to the advantage of the state servant shall be made unless he made an application for the purpose within 3 years from the date on which his age and date of birth is accepted and recorded in the service register or book any other record or service within 1 year from the date of the commencement of this act, whichever is later. After 20 years, that is on 28/12/2020, the such official has made the representation requesting to correct his date of birth on 12/3/1969 in place of 12/2/1968 without furnishing the order from the competent civil court as per sub-rule 1 of rule 5 of the said rules. Hence, it is hereby informed that there is no provision under the rules to consider the said request. But reasoning is not correct because order from the civil competent without furnishing the order from the competent civil court is not, that rule is not applicable to us, my lord. Civil servant. Because section 6 is contrary to that. Section 6, my lord. Because state servant, the department has to conduct inquiry.
3(3) says, notwithstanding anything contained in subsection 1 and 2, the age and date of birth of a state servant accepted and recorded in his service register or book or any other record of service before the date of commencement of this act, in accordance with the rules then in force, shall be deemed to be the age and date of birth. Age and date of birth accepted and recorded deemed to have been accepted and recorded in the service register, or as the case may be, shall, subject to any alteration made under section 5, be applicable for all purposes relating to the conditions of service, including superannuation, retirement benefits.
Section 5, your lordship kindly take minute.
5 says, subject to subsection.
Alteration of age or date of birth.
Department may, at any time, after an inquiry, alter the age and date of birth of a state servant as recorded or deemed to have been recorded in his service register or book or any other record, provided no such alteration shall be made. It's been accepted, record deemed to have been accepted.
The reasoning in the endorsement.
In pursuance of a decree of a civil court obtained by the state servant after he begins a state government. Therefore, if you had filed a suit and got a declaration that what was recorded is not your date of birth, probably could have been done even after the time provided.
Section 6, your lordship.
Alteration to the advantage of a state servant shall be made unless he has made an application for the purpose within 3 years from the date on which his age and date of birth is accepted, recorded in the service. Yes.
But the endorsement states, I have to obtain decree from the civil court, competent civil court. But that is contrary to section 6, my lord.
What does section 6 say?
6, your lordship kindly says, bar of jurisdiction of courts.
Yes,
No court shall have the jurisdiction to settle and decide or deal with any question which is required to be decided under this act.
therefore the service register cannot be changed by the civil code. But if you want to make an application after the 3 years, then you have to have a decree from the civil code.
I will file necessary applications.
That normally it would have no jurisdiction. Therefore, even if you file it and you produce it, then again, the fag end issue will come.
Will come, madam. That is why I have not filed civil.
Even now, the fag end issue is there, because it is 3 years from the date of your entry into service. You wait for all these years from 1991 onwards.
And my proof of this.
Proof, maybe you may have all kinds of proof. But as a matter of fact, they entered into your service record, you did not object. You had all the opportunity to object. If that was not the date, you could have produced the actual date. All that you're producing now. you
That
could have
is
produced then.
produced after lapse of 20 years. That is it.
Yes. Heard the learned counsel for the petitioner and the learned government advocate appearing for the respondent. Okay, having considered the petitioners filed seeking the following reliefs. It is submitted by the learned counsel for the petitioner that the petitioner's date of birth was wrongly entered in academic and service records as 12/2/1968. It is submitted that his correct date of birth being 12/3/1969, he had made an application before the competent authorities for correction of date of birth. On when was your application?
28/12.
28/12,
On 28/12/20.
21.
28/12/20.
21, my lord.
21.
Yes, my lord. 24/12.
On 24/12.
I'm sorry,
2021.
I'm sorry, my lord.
It's 2020.
2020. 28/12/2020.
28/12/2020. Full stop. It is submitted that the said request has been rejected by annexure
My page 47, annexure A8,
annexure 8
24/2/2021.
on 24/2021 on the ground that the applicant could not have sought a change in the date of birth entered in the service register unless it was made within 3 years from such entry or without obtaining orders from the competent civil court. The learned counsel for the petitioner submits that the endorsement is absolutely erroneous since the competent civil court, since the civil court would have no jurisdiction to consider the issue with regard to date of birth of a government servant. Full stop. It is further contended that it is not at the fag end of his career that he has sought a change in the date of birth. And that in the light of the documents which were produced by the petitioner, the request should have been appropriately considered. The learned government advocate would on the other hand contend that the procedure in the
Rule 5(2).
the procedure in the rules relating to recording of age of government servants is provided
Section 3, my lord.
Karnataka State Servants Determination of Age Act 1974. And that section 5 thereof provides for alteration of age or date of birth. Full stop. It is submitted that section 5(2) provides that alteration of date of birth to the advantage of a state servant has to be made within 3 years from the date on which his age and date of birth is accepted and recorded in the service book, in the service register or service book. First, it is submitted that in the instant case, the request was admittedly made after 19 years from the date of entry into service and from the date on which the date of birth was recorded in the service book. It is therefore contended that the rejection of the request by the authority as well as the dismissal of the application filed before the tribunal cannot be said to be illegal in any manner. First, having considered the contentions advanced, we notice that Section 5(2) of the 1974 Act specifically provides for the for an application to be made by a government servant for correction of age or date of birth within a period of 3 years from the date on which the age or date of birth is recorded in the service register. It is clear that in the instant case, the petitioner's case itself was that he came to know of the alteration in the date of birth only in the year 2020, and the application has apparently been made only in December 2020. First, the birth certificate, which is produced by the petitioner in support of his request, is one issued on 21st of August 2021. In the facts and circumstances of the case and in the light of the statutory provisions, we are of the opinion that the rejection of the application by the tribunal on the ground that the request for change of date of birth was belated cannot be found fault with. The petition therefore fails. Same is accordingly.
Precious.
50% of pension withheld.
Only on the penalty, my lord, nothing else. Only on the penalty imposed.
Village assistant, tried on 31/5/2019.
But
Can you get
the
instructions
allegation
in
is
the
quite serious, my lord. The demand of around 4.25 lakhs has been made. My lord, if you were in service, it would have resulted in dismissal.
50%. Please get instructions. Learned government advocate takes notice on behalf of the respondents and seeks.
I'll take out notice on the standing council.
Yes, learned takes notice on behalf of respondent number 1. Learned counsel to serve notice on the counsel appearing for the second respondent Lokayuta. List after 3 weeks.
Please.
Learned
Request on
government
specific
get
date, madam.
instructions in the matter. Was there anybody else involved?
No, ma'am.
No, man.
Just
This is a trap case.
some date, my lord, after 3 weeks.
Yes.
Great.
Charge memo on very same grounds as the
Yes, yes,
criminal case.
yes, my lord.
You're
There is-
saying that it should await.
Yes, my lord. There are 3 grounds that are urged, my lord, by us. One is that the criminal trial as well as the DE are sought to be held on the same facts, grounds, and also documents, my lords. And the second one is that there was delay of 4, sorry,
Yes, sorry.
sorry, my lord. I should-
Yes,
There was delay of, my lord, 4 years, 4 months in, my lord, the initiating DE by the government.
this was also a trap case.
Yes, yes. And, my lords, trap case is, my lord, alleged, but, my lord, we can explain how it has happened. After the, my lord, operation, they say that, my lord, I demanded the bribe. 28, my lord, 5/2018.
Specialist doctor.
Yes, the operation was done on 28/5/2018, and it is alleged that I demanded bribe on 29. Operation was over, my lord. That is a different thing, my lord. What I want to submit is, my lord, on the issues that have been, my lord, urged before the honorable tribunal that have not been considered. Delay of 4 years, 4 months, and the government order, my lord, is also under challenge before the KSAT. And my lord, the other ground is that my lord, the evidence, facts, and my lord, everything is same in the proposed D as well as my lord, criminal proceedings. Criminal proceedings have reached advanced stage. Now I am told by my learned friend that my lord, trial has also started, my lord. And the other thing is that the Honorable Lokayukta can make a recommendation or report under section 12(3). And my lord, he cannot,
It is for the government to either
yes,
accept it or not.
because 14A, my lord, confers that power on, my lord, the government. And it is covered by, my lord, a single bench decision of this honorable court. All these, my lord, contentions were urged. And, my lord, the learned, my lord, chairman of KSAT, who has disposed of the matter, does not consider any of our contentions. What the learned, my lord, the honorable tribunal says is this, that delay cannot be questioned before the tribunal or sought to be quashed before the tribunal is the, my lord, order of the court, order of the tribunal. But our contention was that delay has not been explained at all. They have filed objection statement. R2 has filed objection statement. There is absolutely, my lord, no consideration, no explanation for the delay of 4 years, 4 months. And the law laid down by the apex court says that, my lord, delay is certainly going to affect the rights of the parties. Here, what the situation is that, my lord, if
Delay has to be considered on a case by case to case basis.
there is absolutely, my lord, no dispute about that. But they do not dispute that there is a delay. That is my submission.
Of course, there is a delay because the dates would show that there is a delay. Whether the delay was justified in the facts of
Yes.
the case is in cases where in trap cases, where the matter has ended in acquittal in the criminal trial. We have been seeing some of these cases in the past weeks, which is why I'm saying this. In cases where the trial actually ended in acquittal, and thereafter the matter was taken up by the government taken up before the Lokayukta, and the charges were framed thereafter, entrustment thereafter. This court has held that it can be done. Because that was a case where the trap was in 2007, acquittal in 2011, appeal pending. While so, the matter was taken up, the Lokayukta gives a recommendation for the disciplinary proceedings to start. It starts. The charge memo is challenged before the tribunal, dismissed, comes before this court. The co-equal bench says it can be.
Lordship may kindly see, Lord, your lordships are referring to a fact situation which is totally different. We are in a, Lord, situation where the criminal trial is yet to start or, my lord, criminal case is pending for trial. Charges have been framed.
Is the situation I said not?
My lord, it
not
is
worse
opposite,
from the
my lord.
point of view of
Your lordship may kindly
or a
see.
better case for the petitioner?
Yes, my lord, your lordship may kindly see, my lord. My defense will be prejudiced before the, my lord, the criminal court, because may I request your lordships to kindly see the witnesses that are going to be examined, my lord.
Your contention is that whatever you say before the inquiry may be used against you. in
Yes,
the
my lord,
trial.
it will seriously prejudice, my lord. My lord, in that context, my lord, we have challenged the proceedings initiated, my lord, by the Honorable Lokayukta for disciplinary, my lord, proceedings. Disciplinary proceedings have been, my lord.
Yes.
Ab-
What do you
absolute-
say?
My lord,
This-
your lordships
this
may
one has-
notice the prayer in this case, my lord. The prayer is one, they seek stay of the charge memo on the ground that it will prejudice disclosing the defense in the disciplinary proceedings will prejudice their defense in the criminal proceedings. My lord, the plea of delay is inconsistent with this prayer. On the one hand, they want the disciplinary proceedings to be postponed. On the other hand, they are saying that the delay is going to prejudice their case. My lord, on the other hand, also the plea that my lord, the criminal case, my learned senior counsel pointed out that the criminal case is now at an advanced stage. Now, that is also inconsistent with the fact that there is no difficulty in beginning the disciplinary proceedings because already If the criminal proceedings are at an advanced stage, then it will not prejudice their,
The defense evidence has started there. It may not make any difference here.
and also, my lord, the Honorable Supreme Court has also held, if there is exoneration in disciplinary proceedings, it will automatically lead to exoneration in criminal proceedings. If they don't meet the standard of preponderance of probability in disciplinary
Yeah.
proceedings. No question of meeting the higher standard of proof in criminal proceedings. So it is to their advantage. In fact, the tribunal has noticed that the pleas are inconsistent.
My case is totally different, Lord. I am challenging
The finding of the.
government order, Lord, for initiation of disciplinary inquiry, annexure J, which is dated 3/8/2022, on the ground that there was delay in ordering D. That has nothing to do with my prayer, my lord, seeking quashing
Page.
or my lord, staying the disciplinary proceedings that are initiated by the second respondent. I have challenged them separately.
199 is
It
the,
need not be.
What is the finding by the tribunal?
page 199, my kindly view.
Lordship, sir, in tribunal's order, it starts at page number 192.
In-
Lord.
Yes.
There is total
Where
non,
is where is the findings?
finding, your lordship will find, my lord, para number 7, page number 202. Lordships got it.
The tribunal's statement that the applicant has challenged the articles of charge may not be correct, my lord. He has only sought stay before the tribunal.
It's not challenged.
He has only sought stay of the charge sheet.
We are not,
Charge
my lord, against conducting D. We want that, my lord.
Only you want
Yes,
the,
my lord, it may be deferred for the time being, my lord, because the criminal trial has, my lord, already started now.
what would be the effect of the criminal trial on these proceedings according
My lord,
to?
your lordship may kindly see, my lord. Even if I am acquitted in criminal trial, my lord, there is no bar for the government to, my lord,
Exactly.
conduct D.
Exactly what
My
we-
lord, that is one thing. Second thing is that I have also challenged the government order dated 3/8/2022, which is at annexure J, for ordering disciplinary inquiry against me after 4 years, 4 months.
Entrustment order.
That has not been considered. My lord, delay, my lord, coupled with, my lord, the same evidence in both cases, my lord, are the grounds to be considered by the tribunal. My lord, tribunal says that, my lord, the delay cannot be a ground to question the D proceedings. My lord, that is not correct. My lord, I may refer to, my lord, the position of law with
Yes. Yes, please.
with reference to, my lord, the apex court decisions.
Yes.
My case is not appreciated is my submission. My case is that, my lord, same evidence, same witnesses, and, my lord, same facts. I can demonstrate before your lordship, my lord, that there is no consideration of any of the contentions that have been urged by, my lord, us.
BK Meena,
Before,
etc. have been considered,
Muscle
have
money
been
has-
referred
no,
to.
that is not considered. My lord, what the court says is, it does not actually refer to my contention that evidence is same in both cases. Facts are,
Evidence is bound to be in trap cases, the evidence and the charges are bound to be the same in all cases. It is in identical cases where this court has held that will not prevent the conduct of the disciplinary proceedings. Only point according to us, which has any relevance, would be that the trial is proceeding at this stage. If you are asked to give a response, whether it will have.
yes,
your
ma'am, that is
response
the
would-
case, ma'am, that is the.
would, answer would be quite simple. Would the response would your stand in the criminal case and your stand here, will it not be the same? There, the difference is you don't have to take a stand at all. You can, as a matter of fact, wait for the prosecution to prove their case. You don't have to express any opinion at all. Here you have to. You have to give and whatever you say here may have a bearing. That that,
My instructions
Take
is that,
point.
my lord, 2nd of August, my lord, the trial is fixed there. Now, it's going on. Lord, we only want it to be deferred.
wait for a short time.
Well, it's subject to the condition that they will not raise the ground of delay once again.
No, how can it be?
No, this
Oh,
it's
no.
definitely.
Because
cannot.
it's an inconsistent plea also, my lord. Once, on the one hand, they are seeking
Here, if they give
stay
a
of the
reply-
charge memo, and on the other hand, they're saying delay, because they should be happy that the charge memo has been delayed.
No, now that if they give a reply here and whatever they say in reply, as a matter of fact, can affect the trial and the trial is being fixed.
2nd August.
My lord, that may become a ground in every case, my lord, unless they can show what is the prejudice that will be caused. At least it should be put to the petitioner as to what is the prejudice that will be caused to them if they disclose the defense in the disciplinary proceedings.
Have you submitted your reply to the charge memo?
Not yet,
Not.
not yet.
But the conduct of the petitioner also may be noticed in this case. He did not appear before the disciplinary, the inquiry officer initially. He was placed ex parte, although he received it. He claimed on the ground of ill health, I could not appear. Thereafter, it was condoned and he was allowed to submit his reply.
Now-
Thereafter, he raises this ground.
Till now, it has not been submitted also.
He has not.
Would you, as a matter of fact, have an inconsistent plea in the disciplinary proceedings? Normal cases, you would not. Your plea here and your plea there would
Same,
be, I have
same.
not done it.
Same.
Denial. Plain
No.
denial.
Lordship.
Cannot be anything else. Therefore, what would be the prejudice to be caused if you submit your reply
Yes.
to the charge memo?
My lord, I can submit my reply, that is a different thing, but my lord, the D should be, my lord, postponed for the time being, because let the criminal trial over is your submission. That is the only thing. Lordship may, my lord, say that we can submit our response to the, my lord, D, articles of charge that has been issued. But my lord, the D should not proceed for the time being, is only request, that's all.
Lord, on the one
My lord,
hand,
my
the
learned
petitioner
friend
claims.
wanted me
Understand
to.
the request, but even then, according to us, it would make no difference because even if you're honorably acquittal in the criminal trial, they can still proceed with the DE.
My lord, your lordship may kindly.
Not make any
my
difference.
lord-
It's only that they're being continued in tandem, that normal cases, it's not, normally not done.
That is true, my lord. But what I am submitting is this, my lord, at this stage, I should not be compelled to, my lord, disclose my defense in the.
Suppose any order is passed here with regard to your participation in the DE for the time being, whatever. You can delay the trial,
Lordship may kindly say.
delay the trial and then say that,
No, your lordship may kindly, my lord, in fact, in the decisions that I am referring, my lord, apex court decisions, the Honorable Supreme Court has fixed the time for, my lord, the disposal of the criminal case. 1 year time is fixed, 6 months time is fixed. My lord, that can also be done. Lordship may kindly appreciate, my lord. The witnesses, can I request my lords to kindly, my learned friend wanted me to show the prejudice. I'll show the prejudice, my lords. Kindly take, my lord, page number 37. These are the documents that are sought to be produced in the criminal trial. Kindly take page number 37.
yes,
Lord, D3, left-hand side, my lord, D3. This is FIR copy.
Three.
Yes, my lords.
Mm.
Lordship may kindly come to, my lord, page number 128, which is the articles of charge now. I am referring, Lord, 37, which is part of, my lord, the charge sheet filed in criminal case. Now, your lordship may kindly come to, my lord, page number 128. First one is first information report. Then your lordship may kindly come to page number 38. D7, your lordship may take. Interesting Panchanama is the second document. Then, my lord, D7, item number 7, item number 3 on page 128, entrustment Panchanama. Then, my lord, this number 2 also, complainant's complaint is, my lord, part of this annexure document 3 before the criminal court. Then, my lords may kindly come to 38, D8. White paper containing details. D8 is, my lord, item number 6, details of notes. Item number 6. Then, my lords, your lordship may kindly take D9 on page 38, confiscation Panchanama. That is, my lords, D9, item number 5, item number 5.
Panchanama.
Then, my lord. I will, my lord, just continue 128, my lord. I have examined this. Item number 5 is Caesar Panchanama, which is D9, my lords. My lord, before that, transcription of recording is D13 in the criminal case. Then, my lords, item number 7 is D27, explanation of accused. Then, my lords, 10, item number 10 is D14. Rest of the things are also, my lord, part of the criminal proceedings. Then your lordship may kindly come to 127, page number 127 is the list of witnesses in D. This may kindly be, my lord, seen with reference to list of witnesses in the criminal case. We'll start with it. Yes, your lordship may kindly come to page number 60, my lords.
60.
Yes, my lord, 60.
Yes.
My lord, serial number 1, CW1
Parshuram.
is Parshuram. Then your lordship may kindly see 127 Parshuram complainant. Then your lordship may kindly come to, my lord, serial number 3 on page 60, Sri Manjunatha. Lordship may kindly come to, my lord, 127, item number 3, Manjunatha, serial number 3, my lords. Then your lordship may kindly come to page 61, Shivu Matthew. Then your lordship may kindly come to 127, my lords, number 2. Number 2 is Shivu Matthew. Then, my lords, page number 68, CW 18, JS Tippeswamy, investigating officer. Then, my lord, 127, serial number 4, same witness. Then, my lords, your lordship may kindly also examine this on facts also. Facts of the criminal investigation report are, my lord, the basis for conducting this, my lord, D. I can demonstrate before your lordship, my lord.
Be the case in every trap case. The evidence would be the same, the charges would be the same. In
Lordship,
every trap case. I've come across at least, after coming here, I've come across at least a dozen cases where this court, or the co-equal bench of this court says, is not the bar for conducting the.
My lords, kindly,
Only worry is the parallel, that is, this is the first case I'm seeing of parallel proceedings going, is all.
that's what we are requesting. For the present, my lord,
Parallel would also be permissible, unless of course the actual evidence
the evidence is same.
is coincides. We have never seen a case like that, where the evidence is to be taken at the, this is because of the interim orders of the tribunal, that it has been delayed for some time. There was a stay for the tribunal,
There was a stay for about 3 months or so.
that is all.
3-4 months it was pending.
Initially, the trap was done by the Anti-Corruption Bureau. Thereafter,
Not the.
not the Lokayukt.
When
Lokayukt,
was the Anti-Corruption Bureau done away with? Sometime in 2013 or 14?
not 13, 14, later, I believe it was, Leonard friend says it is 19/10/2022.
It's only
Yes,
2022 that
2022.
the Anti-Corruption Bureau has been done. away.
2016, Lord, Constitution of Anti-Corruption Bureau. Lord, the Constitution of Anti-Corruption Bureau was challenged before, Lord, the division bench of this Honorable Court in a PIL. This Honorable Court declared that it is unconstitutional. Thereafter, Lord, on 9/10/2022, all the files which were pending in the
I've
Anti-Corruption
seen that
Bureau
proceedings. Those proceedings I've seen, but I didn't remember. them.
transferred to, Lord,
Can we have a copy of those as well, only for information?
Please.
Because as on what grounds, I've not seen the judgment. What grounds it has been
Please.
struck down also. Only like to see. Yes.
But delay may also prejudice the case of the state. That may also be considered, my lord, because but as the delinquent government officers claim that because of delay, there it may be difficult to lead their evidence after a very long period of time. It will be the same for the same
4
similar
years.
prejudice will be caused to the
4
state.
years we are seeing in Karnataka is not a delay. We are seeing
Yes,
in Karnataka that
indeed.
4 years is not a delay because
Yes.
so many cases are being initiated because in some places it would be called a
Yes.
delay, but here it appears apparently.
And here the pleadings are also inconsistent. My lord. The ground of delay is inconsistent with the plea of charge against the prayer for stay of the articles of charge on the ground that the defense in disciplinary
You
proceedings.
get instructions in the matter. We'll have it after maybe a little while so that if as a matter of fact, please get instructions as to the proceedings in the trial also.
Please.
The evidence is being led. Let us wait for maybe a month or so and
Please, please.
the learned government advocate takes notice for the respondent and seeks time to get instructions. List after 3 weeks. In the meanwhile, further proceedings pursuant to the memo of charges shall not proceed for the time being.
Annexure D, my lord.
Annexure will
Please.
not proceed for the
Alright.
time being. Please, in the meanwhile, what about submitting your reply? Or maybe on the next date, we can give some time for submitting the reply. And
Until the interim order maybe till the next date of hearing.
till next date.
Lordship may kindly order notice to respond number 2. My learned
Just
friend
to the-
represents government.
Just to the second respondent, complainant.
Obliged.
R2 is the complainant?
No, loci.
Okay. Yes.
Obliged.
Please say no. Please say the next date of your. Transfer,
Transfer.
Repatriation of deputations,
repatriation.
of deputationists.
In fact, my lord, I was transferred to the KIDB from the Revenue Department in the year 2022. It is not on deputation. It is a transfer from the Revenue Department. The
A transfer from one department to another can only be a deputation. How else can it be? What was the post held by you?
manager
Of,
early in the Revenue Department.
there is a post called manager in the revenue.
Yes, and from Revenue Department, I have been transferred to KIDB as a manager.
Only be a deputation. It is a foreign service.
Matter should have been the proceeding should have been initiated before the single bench of this honorable court. Now,
No, it is a order.
KADB is autonomous body. And the order is passed by the KADB. The Karnataka Industrial Areas Development
Which
Board.
has been taken up.
Before the
tribunal.
administrative tribunal.
The impugned order is by the tribe, the board, man.
Reviewed relieving orders also as well as impugned official memorandum.
Annexure B is the.
Application, just a moment. Being authority appointing. This is not raised before the tribunal,
It's grounded.
It was raised,
Yes.
but he is
Maintain.
initially an employee of the state government.
yes.
But the impugned order is passed by the board.
Relieving issued by third and fourth respondent during subsistence of election code of conduct. During the said period, no order of transfer. is clear. Just a moment.
The tribunal dismisses it on the ground that the deputationist has no right to continue in the borrowing department. And also it is said that the KADB has produced documents showing that there were allegations against the petitioner. Therefore, she has been transferred.
A deputation has no right whatsoever to hold the post as it is for the authorities to consider in the circumstances. If services are not required, they can repatriate to the parent department. Learned counsel for the respondent number 2 to 4 has placed reliance on the decision of the tribunal passed in application zones. And we have large number of complaints received against the applicant. Second respondent thought it fit that the service of the applicant is not required for the board. Third respondent has issued order date. Can you hand over the administrative tribunal? Sir? Team. Jurisdiction powers and authority exercisable immediately in relation to recruitment matters concerning recruitment service. All service matters concerning a person, not being a person referred to in clause C of this subsection, or a member person, civilian referred to clause C of subsection, appointed to any civil service of the state or any civil post under the state pertaining to the service of such person in connection with affairs of the state. Pertaining to the service of such person in connection with the affairs of the state or of any local body or other authority under the control of the state government or any corporation owned or controlled by the state government. All service matters pertaining to service in connection with the affairs of the state concerning a person appointed to any service or post referred to in clause B, being a person whose services have been placed by any such local or other authority or corporation or any other body controlled or owned by the state government at the disposal of the state government for such appointment. It may not even be maintainable. Relying on clause B, it is being considered by the tribunal. Because it refers to earlier applications also. We may not go into that then. Yes.
My Lord, the Honorable Tribunal has dismissed my application on the premise that I was on deputation.
How else can you, an employee of the Revenue Department of the state government,
Yes,
be placed at the, in the service of a board?
board.
It is not a state government. How can it be? Which is the order by which you were posted there?
Annexure A1, page 27, my Lord. Dated 22/9/2022. Translated
Saying so and so, Deputy Tahsildar,
to the
KIADB,
as a Shirastedar.
in interest of public administration, immediate effect, it can only be a deputation.
But here it says it is transfer.
Only by saying it is a transfer makes
Yes.
a difference. It is from one institution to another. It can only be a deputation.
But KIADB is
The
up.
deputation, you have no right to continue unless there is, it is, the appointment itself is to be made by deputation in the KIAD. How is it to be made, this post? How is it to be filled up?
And that too within a period of 2 years.
Period of 2 years is not available. That is only for a transfer. If it is a deputation, and if you are a deputationist working in another institution, and the institution does not want your services, there is no, you have no right to insist that you must be continued there. unless you are appointed
by the court.
by deputation, if deputation is a method of appointment. That is, those pleadings are not there.
Here it is transfer from revenue department to
In
KD.
fact, the provision on which they rely on, that says it's a deputation. Rule 50 of the case, they're relying on Rule 50 of the KCSR to say that the consent of the borrowing authority should be taken, but no such requirement is specified in Rule 50. And Rule 50 speaks about deputation. They rely on this section in paragraph, in the very first ground, Malak, in page 22. So they are not denying that it's a deputation in their pleadings before the tribunal. Rule 50 of the
Permanently
cases.
transferred or deputed, that is also different situation. Permanently transferred or deputed from one department to another. That is with regard to when probably a bifurcation or even an appointment by deputation, when deputation is a method of appointment, then this would apply. This is not a permanent deputation in any view of the matter. Your lien continues in the revenue department. Is that
Not a
so?
permanent
Otherwise, how else can you come back to the revenue department? Yes, you'd have to be thrown out of service.
But now the relieving order say that without showing any place of posting.
That we can,
That is by the parent
that
department.
again, we can get that, for that limited purpose, maybe we can get instructions. Yes, learned government advocate to get instructions in the matter with regard to the posting to be granted to the petition, list after 2 weeks.
In the meantime,
I'm sorry,
because my lord,
sorry, there is no ground for a stay.
because no purpose will be served by it.
Then we can pass an order now. There is no
Again,
ground for a stay here.
again retransfer. ADB,
Only one.
2 to
Respondent
4.
number 1.
2
2
to
to 4
4
is
is
KADBs.
Then notice to the other respondents. You want an order on the stay petition?
limited purpose, my lord, because
No, the order would be a negative one.
that too during the election code of conduct, this order has been issued.
Now the election code of conduct is over.
Now, because
Can be now given effect to. No, please go and report. They'll give you a posting and we can close it on that basis. It is only a deputation, can only be a deputation. If it is a deputation, you have no right to say that you should be continued there.
our 22 order says it is transferred by the government.
Is it better that the matter ends here now? You want, we can,
It may be called after 2 weeks. In the meantime, I'll serve the copy and the KDB panel.
no interim order.
There was,
Yes,
in fact, there was an interim order before the tribunal.
we understand. But after this dismissal, we don't find a ground for an interim order. It is admittedly a deputation. Please go and report. When the matter is pending here, probably they'll give you a posting order without delay.
But now I am in the same place and same post.
Please
Because
go and report. Please comply, go and report. You're not inclined to pass an interim order. We don't want to pass an order rejecting that.
it may be taken after 2 weeks,
List after 2 weeks.
some date may be fixed.
Dispensed.
2 weeks.
Early hearing. Can be listed.
Here for the respondent. But matter pertaining to, my lord, selection to the post of, my lord, motor vehicle inspector.
Hmm.
Not I had applied for the post of, my
It's
lord,
not height.
yes,
It is.
height. It is height.
Yes.
My lord, in
And
the,
the Public Service Commission has brought it up. Is it their IA for early hearing?
my IA,
Your IA.
not,
Can hear it on any date? Let them also be here.
but the only order passed by the tribunal is page 143 is the course, my lord, the tribunal has directed for conducting the medical examination afresh, as was done in with other candidates, page 143, my lord.
My lord, I am appearing for the petition in this case, my lord.
Yes,
My lord, I may be allowed and date may be fixed, my lord. Today I am
Yes,
not
yes,
well, my lord.
yes, it can be. We just wanted to see what the matter was about. It can be, it'll be fixed.
Grateful, my lord.
Just a moment. I just wanted to know what the order passed by the tribunal is. That's it.
Grateful.
Considering similar circumstances and effective considering in this application is medical examination was concerned. Fit for consideration, that being the position action subsequently not considered. Yes, we listed it next week. Here it is.
Obvious, my lord.
Yes.
But as an officer of the court, I have not argued this point with regard to height before the tribunal, to the effect that, my lord, without reference to the height, please appoint
That's
me.
true.
That
That was not taken up
I
there.
have not argued, but
We'll have to consider on the materials that are there on record. Well, it is
yes,
you could argue that it is a legal provision. Anyway, for next week,
Grateful.
Anyway.
yes.
but same. But it is not height, it is knock knee.
Nagaraj Hegde. 100 days delay. Notice has to go. Notice to the respondents by speed post. Right. Notice to the respondents. Yes.
So number 5, passed down matter. Mubarak Baker.
Happy for the appellant. It's a defendant's appeal, my lord. I have filed the application under section 8 of the Arbitration and Conciliation Act to refer the matter before the arbitration, my lords.
What is the provision with regard to reference to arbitration in the contract between you?
My lord, as in view of the class 31 of the arbitration agreement, which I have produced your lordship at annexure B, your lordship.
Annexure B page.
Annexure B, page 66, your lordship. Class 31.
Page 66.
Page 66 of the.
What is that agreement about?
This agreement about between the parties, in fact, the appellants.
30th day of August 2008.
May I read your lordship?
Yes.
Clause 31. In case of any dispute between both the parties of the first and second part, the same shall be resolved through arbitration. For the purpose of holding such arbitration, it is mutually agreed between the parties that the arbitration shall be Mr. R.P. Ramanathan, B.Com. BL, PJBA, advocate at door number so and so, lordship, with conduct the arbitration proceeding in accordance with the Indian Arbitration Act, and the arbitration shall be held at Bangalore, and the language shall be in English. Your lordship, as this clause 31 was initially invoked by the plaintiff by issuing a notice.
Just a moment. What is this agreement about?
This agreement.
Terms and conditions, the party of the first part company shall be given exclusive rights for marketing, entering into contracts. So live shows, studios, recording companies on behalf of so-and-so during tenure shall have rights to record albums. So-and-so.
The appellants are the music
rights. Yes.
Founders of the music band, namely as Mother Jane, and there were certain music compositions, your lordship. In fact, they are the original founders of this music band, Mother Jane, and the company, the respondents, Oh My Artists, represented by one Mr. Suraj Mani, who was also one of the members with the music band as an vocalist.
Just a moment, counsel. Please tell us. Before going into the details, what
Please.
was your suit for?
My lordship, the suit filed for, may I refer your lordship to the prior of the plaint at page 181. Annexure R, your lordship.
You only want to know whether it comes within the ambit of the first agreement, of the agreement which you say there
Yes,
is
your
an
lordship.
arbitration clause.
And prior to that.
180?
181, your lordship. My lordship, prior to referring to this plaint, I would like to refer to the arbitral decision passed by the sole arbitrator. May I be permitted to read? In fact, both the relief sought by the plaintiff is same. By virtue of the assignment deed, they have sought before they have invoked the arbitration. Once the arbitral decision was passed, he has been recused from the proceedings because of his non-competency after filing my application. Then, my lord, they have initiated these commercial proceedings with by virtue of the similar assignment deed and the same relief, my lords. So prior to
Now,
referring,
please read the, what is the prayer in the suit?
please, my lord, page 181, my lord, prior, my lord. An order for permanent injunction restraining and enjoining the defendants, their partners, principal officers, servants and agents and all other acting on its behalf as the case may be from utilizing Mother Jane and any other deceptively similar mark belonging to the plaintiff by virtue of the deed of assignment deed dated 30th August 2008, your lordship. Then, my lord, an order for permanent injunction restraining the defendant, their agents, principal officers, servants, all other acting on their behalf from utilizing, performing the copyrighted compositions and songs vested with the plaintiff by virtue of the deed of agreement dated 38th August 2008, my lord. This deed of agreement is nothing but an arbitration agreement, my lord. Then, my lord, they have also sought, prior same, my lord, page 182, they have also sought for the damages.
What happened in the arbitration proceedings?
My lord, I would like to refer to the arbitral decision, my lord, passed annexure P, my lords.
Page?
Sorry, my lord. Before referring to the arbitration decision, my lord, I would like to refer the application which I have filed before the arbitration proceedings, my lord, which is at annexure M, my lord, page 138, my lords. This is an application under section 12 subclass 3, 138, my lord.
Yes. 138.
138, my lords. Annexure M, my lords. This was the application filed by the appellants before the arbitration proceedings, my lord. On this application, my lord, the arbitrator has passed in arbitral decision at page 148, annexure P, my lords. May I read, my lord? This decision was passed. The arbitration clause 31 in the agreement deed dated 38/2008 executed into between the above parties is reported below. Then the same was extracted, my lord. My lord, before that, my lord, the relief sought by this plaintiff has been clearly narrated by the sole arbitrator, my lord. The disputes arose between the parties regarding misuse and infringement of the IP rights, name, logo, copyright issues of the musical album, and composition, lyrics, songs, audio, and visual works, and stage public musical performances, etc. in the name and style of rock band named Mother Jane. And therefore, to resolve the dispute, the said arbitration clause was invoked by Mrs. Omai Artists Private Limited, Bangalore, through their advocate, Mrs. Samvat Partners, so on, so my lords. This was the relief sought before the arbitration, my lord, by virtue of the assignment deed, my lords. Then, my lord, page 149. Then, my lord, this is the decision. This sole arbitrator was recused from his proceedings because of his non-competency for not revealing his relationship with the plaintiff, my lord. Based on the application filed by me, he has been recused. Immediately after this order, my lord, I have issued a notice of dispute, which is at annexure Q, my lord. Page 152, my lord.
150?
152, my lord. This was the
Yes.
notice of dispute issued by me, my lords.
Yes.
May I read, my lord?
Yes. You need not read the entire thing.
Entire, my lord.
Yes.
Page 163, my lord, the last portion, my lord. Wherein I have suggested the name of the arbitrator, my lord. And thereafter, I have received a reply.
Just
at
a,
annexure
just a moment, 163.
163, my lords. The last page of the notice of dispute.
Yes.
Then, my lord, I received a reply at annexure Q, my lord, Q1, my lord, 164, wherein refusing, my lord, may I be permitted to read? In fact, in my notice of dispute, I have never said that the jurisdiction will not be at Bangalore. In fact, in the reply, it has been stated that refuse to accept my notice of dispute, my lord. Then, my lord, I have immediately filed a CMP petition in CMP 466 of 2023, which I have not annexed before this honorable court, along with my petition, which is notices have been issued to all the respondents, and it is pending for hearing, my lord, CMP petition. In the meanwhile, my lord, after issuing this reply, my lord, the plaintiff has already initiated the commercial proceedings before the commercial court at OS number 1310, my lord. I have entered my appearance, my lord. In my written statement, my lord, I have filed the written statement at annexure U, my lords.
Yes.
Page number 223, it starts, my lords.
Yes.
Then, my lord, at page number 22, para 6, my lord. May I be permitted to read, my lord?
Yes.
It is further submitted that as per the deed of agreement, clause 31 of the said agreement, it is clear that any dispute between the parties to the contract shall be resolved through arbitration. When there is a clear clause for arbitration, the present suit is not maintainable, and the defendants have already commenced the arbitration proceedings by issuing the notice of dispute to the plaintiff, and the same was replied by the plaintiff by giving vague reasons. Hence, the defendants have filed a civil miscellaneous petition in petition 466 of 2023. In the light of the arbitration clause, the present suit is not maintainable, and this honorable court do not have the jurisdiction to entertain the present suit. Hence, the same shall be liable to be dismissed. This is in my written statement itself, my lord. I have pleaded about the arbitration.
What is the
clause.
finding by the court?
My lord, I would come to the findings of finding of the court. While rejecting, there are two reasons have been adduced. One is that I should have filed my application before filing the first statement, my lord. My application has been filed belatedly. And the second reason was adduced was I have not produced the original arbitration agreement along with my application. Therefore, it is not in compliance of the provisions, my lord. These were the two reasons have been given. In fact, my lord, for the reason number one, which says that I have not produced the original arbitration agreement. I would like to refer the application what I have filed before the honorable court. My lord, which is at annexure, yes, my lord.
Yes.
Page number 190, my lord. It starts at page number 190, my lord.
Just a moment. You should
Accompanying
refer to-
affidavit, my lord,
be entertained
at
after
page
this.
number 198.
Available with the party applying for reference to arbitration. And the said agreement or certified copy is retained by the other party. That the parties who are applying shall file an application along with a copy of the arbitration agreement and the petition trail. The court to call upon the other party to produce the original. Yes.
My lord, my application, my lord, annexure is page 198, my lord.
Yes.
Page 198, para 10, my lords, wherein the defendants have already pleaded about the original arbitration agreement, my lord. May I read, my lord?
Yes.
I state that the plaintiff has filed a memo dated 3/1/24 to produce the original arbitration agreement and also the assignment deed before this honorable court. As the original arbitration agreement is already produced before this honorable court by the plaintiff's company itself, the defendants are producing the copy of the same along with this application. Therefore, my lord, the original arbitration agreement is already on the court records, and I have also pleaded in my affidavit. And I have also produced the certified copy of the said memo filed by the plaintiff, my lords, at annexure T, my lord. Page number 219,
Yes.
219, my lords. This is the certified copy of the memo produced by the plaintiff, my lord, and 220 wherein clearly describe the documents which they have produced. When there is already, it is on record before the honorable court. My pleadings have been totally ignored and my application was rejected. And also court has found that I have not filed the first statement before filing of my application. To that effect, my lord, I would like to refer the judgment, my lord. I may be permitted to produce a copy of the judgments, my lord. The first, may I know?
Statement of the substance of dispute. Yes. Therefore, if you file a written statement saying that there is an arbitration clause and that the party should be referred to arbitration, that would not be the first statement.
Yes,
For
my
Section
application
8.
was filed belatedly, my lord. That was the reason given by the Honorable Commercial Court, my lord. My lord, the first judgment, my lord, Messrs. Sundaram Finance Limited and T. Tangam by the Honorable Supreme Court, my lord. In
Yes.
page 6, my lord, para 10 of the said judgment. May I read, my lord? Once there is an agreement between the parties to refer the disputes or differences arising out of the agreement to arbitration, and in case either party ignoring the terms of the agreement approaches the civil court and the other party in terms of the Section 8 of the Arbitration Act moves the court for referring the parties to arbitration before the first statement on the substance of the dispute is filed. In view of the preemptory language of Section 8 of the Arbitration Act, it is obligatory for the court to refer the parties to arbitration in terms of the agreement as held by this honorable court in Anand Gajapati Raju and others versus PVG Raju and others. Then, my lord, the plaintiff has also taken one more contention, my lord. The dispute is different here before the commercial court. and the dispute before the arbitration proceedings is entirely different. So two contention cannot be taken, my lord. And for this, my lord, this judgment clearly state, my lord, then there cannot be two different cause of actions, my lord. May I read, my lord?
Yes.
Page number 8, my lord, para 17 of the judgment, my lord.
Yes.
Secondly, such bifurcation of suit in two parts, one to be decided by arbitral tribunal and the other to be decided by civil court, would inevitably delay the proceedings. The whole purpose of speedy disposal of the dispute and decreasing the cost of litigation would be frustrated by such procedure. It would also increase the cost of litigation and harassment to the parties, and on occasions there is possibility of conflicting judgments and orders by two different forums. Therefore, my lord, the cause of action is bifurcated by the plaintiffs here, my lord, stating that. Then, my lord, with regard to the first statement or the contention taken in the written statement, I would like to refer, my lord, the second judgment, my lord, wherein a detailed discussion has been taken place upon the similarly placed issue, my lord.
Yes.
Page 13, my lord, para 20, sub para 20, wherein it has been extracted, my lord. May I read, my lord?
Yes.
Before dwelling upon the issue, it is pertinent to mention here that defendant has taken an objection with respect to continuation of the proceedings before this court despite having an arbitration clause in the agreement. In respect, it is stated that objection with respect to arbitration clause is to be taken before submitting the first statement of defense before the court, which was never done by defendant in the present case. Therefore, this objection cannot be, I'm sorry, my lord, I'm reading, the questions, my lord, page 14, my lord.
Yes.
Two questions arise for determination in the present case, both pertaining to section 8 of the 1996 Act. The first is whether defendants in a suit who seek to invoke section 8(1) have to do prior to filing of the written statement as held by the learned ADJ. The second is whether a mere objection to the maintainability of the suit advanced by the defendants in the written statement and predicated on section 8 and existence of the arbitration agreement between the parties would suffice, or whether a formal application seeking reference of dispute to arbitration is necessary, my lord. Then, my lord,
What was your written statement?
my lord, in my written statement at annexure U, my lord, I have pleaded, my lord.
You've only raised this contention with regard to the,
But there is no specific prior, my lord. But I have raised the contention with regard to the maintainability and the existence of the arbitration agreement.
is that all you have stated?
Yes, my lord. And
Or
para
have you
80
entered into the merits of the
And I
dispute?
have also brought before the Honorable Court that the CMP petition under section 11 is pending before the Honorable High Court.
That is all? Is
Yes.
that all? Where is the written statement?
At page 223 of the paper.
My written statement is at page 223, it starts, my lord. In fact, my lord, I have not waived my right to refer the matter before the arbitration proceedings.
Question is, have you gone further?
My lord,
Question is, have you gone further? You could have filed a written statement, but the written statement should only refer to the arbitration clause and say that the dispute is not triable by the commercial court.
Yes.
Is be considered in the arbitration proceedings. If you have gone further into the merits of the case, then section 8 would be, your application would be belated. It is the contention here. What have you said?
My lord, this judgment, what I have produced, my lord, it says, my lord, the contention taken in the written statement would suffice, my lord.
Counsel, that is all you must say in your written statement. Have you gone on to say about the merits of the dispute?
Yes.
Then your section 8 would be belated as the contention that has now been taken against you. Please answer me that. Please answer that.
Pardon, my lord,
You have gone on, you've stated that the matter is to be referred to arbitration. There is an arbitration clause in the agreement.
yes, my lord.
Well, for the section 8 to be maintainable, you should stop there. If you've gone on and pleaded on the merits of the contention before the commercial court, then what is the need for you to say all that before the commercial court? If you are serious about the arbitration clause and that the remedy being under the Arbitration Conciliation Act, you cannot raise disputes on merits before the commercial court. All you need to say is that there is an arbitration clause and the matter is to be referred to arbitration. If you go further, you say that in the written statement, but you go further and raise all other contentions as well, and thereafter file a section 8 petition. Would it be maintainable?
Yes, my lord, as per this judgment, my lord,
The
kindly.
judgment does not say so. Judgment does not say so. Judgment you are referring to does not say so.
My lord, I may be permitted to refer. Page 29, my lords. Page 29. Wherein the second reason why the submission. Sharat P. Jagatniani specifically para number 14 to 17, my lord. This, in this judgment, it has been extracted, my lord. My lord, para 15, my lord. Section 8 does not specify the manner in which the party has to submit its first statement on the substance of the dispute. And normally, with respect to a suit, the first statement on the substance of the dispute by the defendant would be the written statement. Thus, if in the written statement filed, it is brought to the notice of the court that there exists an arbitration agreement between the parties, which embraces the subject matter of the suit, there would be complete compliance with the mandate of law under the court, would be obliged to refer the parties to arbitration if the plea in the written statement is made good. Then, my lord, page 31, my lord.
You're reading in parts and pieces.
My lord, I will.
Obviously, a party who willingly participates in the proceedings of the suit and
Please.
takes himself to the jurisdiction of the court cannot subsequently turn around and say that the parties should be referred to arbitration in view of the existence of an arbitration agreement. Whether the party has waived his right to seek arbitration and subjected himself to the jurisdiction depends upon the conduct of such party. Right?
I am reading, my lord, which specifically says about the written statement, the pleadings taken in the written statement, my lord. In page 31, my lord. In the same similar judgment, para 15. The next question for consideration is whether the making of an application under section 8 is necessary or the plea substantially of section 8 in the written statement suffices. Though subsection 1 of section 8 merely talks of if a party so applies, and which can also be in the written statement, but subsection 2 and 3 of section 8 do mention an application under subsection 1. However, in my opinion, the legislative changes as contained in section 8 of the 1996 Act as from section 34 of 1940 Act is not indicative of an application, separate from the written statement being necessitated to be filed for invoking arbitration agreement between the parties.
Which paragraph are you reading?
Page 31, my lord, it is below para 40, my lord. The extraction of this judgment.
The page number is incorrect, counsel. Page 31 in my copy is
Internal page 20 of the judgment, my lord, para 40, my lord.
internal page 20,
20,
not page 40.
para 40, my lord.
I mean, if it is not page 31. Internal page
20 minutes.
Council, after page 16, what you have given us is page 29.
I apologize, my lord, maybe
My lord, may I assist now on, there is a.
May
differentiation
I
here.
be permitted to?
Yes,
My lord, the main issue here is
yes,
two different agreements,
yes,
both dated 30th August 2008.
yes,
One is an assignment agreement
yes,
by which intellectual property rights
yes.
were assigned by appellant number 1 and 2, including a few others,
Hmm.
to me. I am a music label called
Hmm.
for my artists. My lord, there was also a second agreement called deed of agreement, by which a contract was entered into, wherein 5 music albums would be produced over a period of 5 years or till the albums have been produced. And
That does not contain
so
an arbitration clause.
the second agreement has an arbitration clause for the production of music albums. For the assignment of intellectual property rights, there is no arbitration clause, first of all. And second of all, my learned friend, while she was reading the reliefs that I have sought before the Learned Commercial Court, I have not referred to the deed of agreement, which has the arbitration clause in my suit. If my laws want, I can read the reliefs again, but I can just state that in summary. One is not infringing the trademark and copyright belonging to me, that is the plaintiff, pursuant to the deed of assignment. Second is not performing any music shows and violating and using the word Mother Jane and the copyright songs pursuant to the deed of assignment. So both my reliefs are completely premised under the deed of assignment, and there is no interconnection or correlation with the deed of agreement, which has the arbitration clause, which is 30th August 2008. Now, both these.
Ask you one simple question.
Yes, madam.
You own the copyright.
Yes, madam.
There is only one band.
Yes, there is only one.
They have the music.
Please, my lord.
They have the music,
No, my lord.
apparently.
No, I am the owner of both the name of the band as well as the songs. The trademark and copyright both belong to me.
Are you a singer?
I'm a company, I'm a music label.
Exactly just what I thought.
But
One
of the
person,
band-
one person holds the intellectual property rights, one person holds the ownership, and the other person has the music. Is it not in both your best interests that you try to settle this out of court so that some kind of an agreement can be reached so that the music as well as the ownership can go in tandem?
My lord, I made a very conscious attempt at that. My lord, just to add to that narration, there were total 5 band members who had entered into the deed of agreement as well as deed of assignment. 2 band members are the appellants for this honorable court. I, as a company, one of my directors is the 3rd band member. And there are 2 other band members who are acting as authorized artists for me. So it is not there.
It is
So-
split down the middle.
It is a band which has split across 3+2. And my lords, the appellant, the entire list of this dispute started off in 2022. There's some WhatsApp messages placed therein. I will not go into that right now.
I've seen a few of those when I was.
Appellant approached me. He said, let me use the name and produce more albums. I said, yes, go ahead. You can give me 100 rupees a year just to establish the fact that I continue to own the IPR. My lord, I cannot go below 100. Like, that is a very fair, reasonable offer that I had made. But the appellants turned around and said, no, you do not own these rights altogether. And hence we are in this dispute. My lord, so this company run by the vocalist of the band itself, one of the directors is the vocalist
No,
of the band.
before you lose the substance of this dispute as it is, we just thought that it may be possible for you to attempt to sit across a table and talk this out, if there is a chance.
My lord, I am always inclined rather to settle rather than to be in this list.
My lord, in
But
fact,
why not?
this, the appellant's respondent's company representative, Mr. Surajmani, who worked as an vocalist, my lord,
Forget the names, just think of the continued existence of the band and your name. After a while, do you think anybody is going to remember this name? If you're not in the market for a while, that will be the end of it.
Yes, my lord, once
In both your best interest that an attempt can be made to settle this out.
I'll seek instructions, my lord, to that
Get
effect.
instructions on that instead of going full throttle on a legal battle.
Please, my lord. My lord, one submission, my lord. In fact, Mr. Surajmani, who worked as an vocalist, he retired in the year 2011, my lord. which he has been admitted in his plaint itself. After his retirement, my lord, he kept quiet up to March 2023, my lord. Suddenly, he wakes up and issues notice to the music band stating that it is claiming the name, trademark, and the music composition.
When you're attempting a conciliation, let's not aggravate the issues.
Please,
There'll probably
I'll see.
have to be some kind of negotiation or some kind of giving up on claims on either side. It's only when both are ready for such a settlement that a settlement can happen. We just thought
I will
the
seek
facts of this
instructions.
case, where what is the dispute is with regard to a ban. And these are things that are short-lived. It cannot exist forever. If you're out of the reckoning for a while, then after a couple of years, nobody remembers the ban. There won't be a requirement for the band as such. So while the name is still there, if it is, we are not on the facts of the case, we're just thinking, if as a matter of fact, it is alive and there is, apparently there's some value to it because you are both fighting over it as at present. When that name means something, if you can settle this, maybe it will be in your best interest.
I'll seek instructions, my lord, and I'll keep the parties present, my lord. My lord, but the proceedings before the commercial courts are going on, my lord.
My lord,
It did not go
It
on
may
for
be
the-
stayed, my lord, till then, my lord.
There'll be no stay. It can be, you can both inform the commercial court that there is a chance of settlement. You can get it adjourned to another date.
my lord,
For that purpose, we can say that there is an attempt to settle. That is all we can do. We'll list it tomorrow. Tell us whether there is any chance. If there is not, then we'll have to decide it on this appeal also will have to be decided on merits.
Please.
Tell us if there is any chance of a settlement. If there is, we can record it here so that you can get an adjournment in the matter before the commercial.
my lord, informed by my colleague that the matter before commercial could today has been adjourned to 5th of August. So tomorrow we will be present before this court.
Please tell us whether there is any chance.
Please.
No, if as a matter of fact, there is absolutely no chance, then the parties need not be present. It's only if there is some chance that, and even then the parties need not be present, we can refer it to either to mediation
My
or
lord,
whichever way you want to set it.
I'll seek instruction.
Please.
I'll also seek instructions.
My lords, we have already filed a wakalatnama with the KVA. If a name can be reflected on the cause list.
There will be some of the objections.
I'll-
Call for it and record it so that its name can also be shown tomorrow.
Much obliged.
My lord, I apologize for the mistake, my lord. I'll correct it.
All those pages are not there. From 16 to 28 are not there.
I do agree, but I apologize for inconvenience. Much obliged.
That's tomorrow.
Tomorrow.
Permitted to, tomorrow I'll file it.
If required. If there is a chance of settlement, then you don't have to. Yes,
B group. Cell number 17, Bindu you.
promotion of the fourth respondent challenged. On what ground? What is the post?
At present, he is working as a deputy commissioner and he is eligible for a promotion to the post of commissioner.
Monday is a no service day. Should we continue that? Is it required? Then we'll have it on Tuesday. Yes, that is what I thought. Let's continue that from next week onwards. We'll say 6th. Yes.
18, Gurraj.
Yes,
I am for the petitioner, my lord.
regularization rejected,
Yes.
Umadevi.
Kindly provide us 2 weeks' time so that I can submit
Yes.
all the translated copies.
Yes, list after two, learned counsel for the petitioner seeks time to produce the translated copies. List
But-
after 2 weeks.
Obliged.
Yes,
19, government advocate.
compassionate appointment to sister,
Appointment.
to sister of the deceased.
Clearly it is contrary to the.
Sister is not.
Sister is not.
Family.
Sister is eligible, but she should be living with the deceased. Well,
Not
she
in
was,
This case.
not in this case, she was actually married, but she was, the tribunal finds that she had already filed divorce proceedings and the proceedings came to a conclusion only after 1 year,
The
which is
brother,
the
brother passes away. There's
Brother-
only the mother and the sister, nobody
Sister.
else. Those are the facts.
The son was divorcee as well. He died in harness. My lord, your lordships may kindly look at the rules that prevailed.
The tribunal seems to have gone a little beyond the rules.
ಇದೆ ಕೊಟ್ಟಿರಿ ಕೊಡ್ತೀನಿ.
Let's give one copy. The
Yes.
the service manual. But in fact, your lordships may refer to the impugned order itself. The impugned order refers to the relevant provision. Alright, which is rule 3, mal. Appoint the rule 3(2), sub-rule 2. Appointment under these rules shall be restricted to the
Yes. Who were dependent on him and were living with him.
the note under rule 3(2),
Hmm.
the note in case spouse is predeceased, then preference shall be given in the order of age of children. In the case of deceased male unmarried government servant,
Hmm.
his brother or sister who is chosen by father and mother, or in case of difference in their opinion, chosen by mother, who were dependent on him and were living with him. So it can neither be said that she was dependent on him or living with him. And she also gets alimony in the divorce proceedings, my lord. That has, and a very strange reasoning has been given. She is a dependent on the brother, on her deceased brother, because her mother was also a dependent. That is the reasoning of the tribunal.
The difficulty would be, what would the mother do? The mother gets the death benefits.
Yes, ma'am. She gets DCRG amount. And the finding is that there is no family pension.
There's no family
There
benefit.
is no family pension.
Why?
But that is the,
Why is there no family pension? Only the mother is alive. Why no family pension? Does a family pension, what does the family pension rules have to say about that? Because if the mother is dependent, she should get the family pension. Only the wife will get. Is that so?
Below 18, if there any male.
That is true.
Other is not. Even father.
DCRG has been given.
You see. Strictly speaking, rules do not provide, but you were married away. You were living with the husband at the time of the. Will you get instructions? You don't have. There's no contempt file? No contempt.
Well, there was a stay granted.
There was a.
There was a stay granted pursuant to which the contempt proceedings were dropped.
Please get instructions. We'll see. Please look this up and submit.
And there is also the limitation period for making the application is 1 year. So the deceased the government servant died on 5/4/2016.
Hmm.
And the application was made only on 18/9/2017.
Please look this up. Start to be. Government counsel appearing for the private respondent seeks time to get instructions. It's after 2 weeks.
August. 20, Narsimurthy.
Disciplinary inquiry. Punishment of, what is the punishment? it
My
was?
lordship, it is only issuing the check in respect of the supply of the laptop. It is a bribe, is only the demanding bribe of 5,000.
Only?
5,000, my lordship.
It is bribe.
Yes, my lord. It is only in the
It is a trap case.
trap case, and it is already, my lordship, in the acquitted in the criminal case, my lord.
Yes. What is the punishment imposed?
My lordship, in the government order, my lordship, in the page number Annexure C, my lord.
Hmm.
The last portion, my lordship.
Hmm.
In the background of the reason explained in the detail at the preamble relating to the charge of the receiving the illegal gratification as per the recommendation of the Honorable Upalokayakta
Hmm.
in excess of the power under Rule 214(1)A of Karnataka Civil Service Rules 1958, it is hereby ordered that to impose a penalty of withholding of 25% of the pension from the pension of Sri K.C. Krishna Shetty, retired Deputy Director of former Deputy Director, Public Instruction Department, Hassan.
Deputy Director.
DDPI,
Public
my lord. At the time of in the trap, so he was working as a DDPI, my lord.
Hmm.
So after the inquiry, my lordship, it is a recommended report to the government, my lord. Without holding the proper inquiry, my lordship, it is a department is referred to the so and so, my lordship, in the withholding is 25% of the East pension. He was retired in the year of 2012, my lord.
Hmm.
So after the, my lordship, in respect of the criminal case, my lordship, in the annexure,
Hmm.
annexure E, my lordship.
Annexure?
Annexure E, my lord.
Page?
Serial page number 67.
It wasn't demanded a bribe. Krishna Shetty.
Krishna Shetty, my lord.
Krishna Shetty demanded a bribe of 10,000 rupees for a laptop of.
Laptop, my
52,000.
lord. It is a no.
Laptop of 52,000 rupees.
So, my lordship, no inquiry, my lord. And my lordship, in the receipt is a bill issued by the, so not received any amount, my lord, but
Hmm.
not received, but is a demand is a,
Where is the finding in the criminal proceedings? Trial.
my lordship, in the special C,
Hmm.
9 of 2012, my lordship, in the annexure E is acquitted. My lordship,
Maybe on what ground?
my lordship, there is no any evidence in respect of the prosecution. It is not true.
Benefit of the doubt.
Benefit of
Benefit of doubt.
not honorable.
The evidence would show that the above referred evidence of PW7 in cross-examination proved that without verification of the concerned documents, he issued a sanction order. That is all that is benefit of the doubt procedure.
Yes, my lord. Without proper inquiry, my lordship, in the department recommended to, so withholding the pension of 25%.
Which is
And-
that order?
My lordship, in the annexure C, my lord.
Page?
Page, my lord. In the 56, my lord. The last portion order, my lordship. Government order number ED 26 DGP 2013, Bangalore, that dated 13/3/2018, my lord. In background of the reasons explained,
Just a moment, 54, page number 54.
Yes,
The letter read as serial number 3 above. The Registrar Karnataka Lokayukta Bangalore has conducted inquiry with regard to charges leveled against K.C. Krishna Shetty, so-and-so, and Jnana Prem Kumar, First Division Assistant Office of so-and-so, and submitted inquiry report together with recommendation letter of the Honorable Lokayukta for further necessary action of the government. In the said report, why do you say that there was no inquiry? Was an inquiry conducted after the 14A enforcement? In the said report, it is reported that the Lokayukta has conducted investigation, conducted inquiry with regard to trap laid by Lokayukta on the date so and so, and when the said persons are receiving illegal gratification, they have been trapped, submitted report based on the inquiry report. Lokayukta in his report dated 4/4/2017 has reported that receipt of illegal gratification by the said officer employee has been proved and has proposed and recommended as per Rule 8(7) of the 8(8) of the Karnataka Civil Service Rules. Since retired, penalty of withholding 25%. Show cause notice, copy of the inquiry report on the inquiry conducted by the inquiry officer of the case of recommendation letter, so and so, so and so. You've been served with everything.
my lordship, in the only Upalokayukta is the report submitted before the my lordship in the before the government consent. Government is only based on the Upalokayukta report. It is only in the holding the 25% of the pension, my lord. So he was retired in 2012, my lord. So it is any bribe not received by the
Grave misconduct has to be proved. What is your reply to
my lordship in the reply, my lordship in the annexure
Hmm.
B, my lord.
Hmm.
Annexure B, my lord.
Hmm.
So my reply already is there is no any amount demand to the complainant. It is only in the my lordship in the complainant's
So there was a trap. Trap is not disproved even in the criminal trial.
It is already, my lordship, in the special case is already acquitted. It is no any evidence, my lord. Ultimately,
Trap is proved.
trap is proved.
Trap is proved even in the criminal trial.
But it's
Only
only
whether, only the question was whether the offense alleged against you should prove. In the trial, it was not proved.
oh, madam. So
Therefore,
my
the
lordship,
trap stands proved.
but is Upalokayukta, it is only to conduct the inquiry, my lord, without departmental inquiry, my lord.
Just the
Without departmental inquiry.
That is the departmental inquiry. There is the power under the rules to entrust departmental inquiry with the Lokayukta.
So after my lordship, it is after the inquiry prosecution in the special CC. So there is no any evidence regarding he is demanding bribe, my lord. So it is in the criminal case.
Establish the defense case, so and so. Your contention is that complainant has admitted that he supplied computer worth 36,372. He submitted a bill for 52,239. Even though he stated the bill was pertaining to a separate computer, bill was separate, there was no order for delivery of 2 computers. Case of Lokayukta.
My lordship, in the my reply in para number 41, my lord. So that earlier his occasion is a case in MAG so and so, he was registered against the complainant. Complainant against also the 2-3 cases against him. And he was sent to judicial custody for having the abusing the abused to Tahsildar.
These are on the facts of the matter. The facts of the matter have been examined by the Lokayukta. Now tell me, we are after one examination, we are here considering the matter only under judicial review. Tell us what is the error that has occurred with the tribunal in considering your contentions.
But the tribunal, my lordship, after challenging this order before the tribunal, my lordship, the tribunal also, it is only in basis of the already trap is proved. But is one, but ultimately, my lordship, in the after the trial.
So all that is required in a disciplinary inquiry. it doesn't have to be proved like in the trial. Because there, the prosecution has to prove every aspect of the matter, and that your guilt has to be proved beyond any reasonable doubt. Here, it is only a disciplinary inquiry. The Lokayukta considers it, finds you guilty, and submits an inquiry report. Is there anything on the procedural aspects or conduct of the inquiry that you can?
My lordship,
What is available to you is a small window.
except this case, my lord, except this false allegation, my lordship, in the service of the petitioner, there is no allegation, my lordship. It is without any blemish service, my lord. He was awarded, so many awarded, my lordship, in the at annexure, my lordship, in the F1 to F10, my lordship, he is awarded to the government of Karnataka. He is the best awarded. But he's falsely is complaint lodged against the bribe, my lordship. Even though, my lordship, in the Lokayukta, it is not properly is investigated, my lordship.
Shivakumar KP complainant, PW2 HS Ravi shadow witness, official in the KSRTC, Hassan, PW3, retired DSP, who's the investigating officer. Investigating officer is clearly deposed regarding the entire investigation, trap conducted, seizure of amount. Even another witness, TD Manjula, the so-and-so category deposed regarding for also only for DPP. Manjula is examined in order to establish defense. Since the check was ready on 16/4/2010 itself, they have not demanded any bribe amount on 19/4/2010. Question of trap does not arise. Applicant and another person are innocent, but as per evidence of the complaint, other witness, it is clear the check was not ready as contended by them. They have demanded and accepted the bribe. Yes, can we continue?
Please.
You want to continue today or on
My
another
lordship,
day?
I have it next week, my lord.
If there is anything on the,
Kind consideration, one submission, my lords.
just a moment, just a moment. If there is anything which we can consider in a challenge to a disciplinary proceedings, please tell us only that. Facts will not help. Facts we cannot consider. We have not
May I
considered-
may I submit,
Yes,
my
yes.
lords?
Yes, sorry. Tell us.
Plus,
Please.
item 52, I am withdrawing that. I have filed a withdrawal memo also.
Yes. Please.
Both, yeah, the writ appeal and contempt, I am the, for the complainant in the contempt and appellant in the writ appeal.
Yes, it is submitted by the learned counsel appearing for the appellant that both the contempt, the writ appeal as well as the contempt of court case are being withdrawn. Submissions, the memo is also placed on record. The memo is accepted. The writ appeal as well as the contempt of court case are dismissed as withdrawn.
Are closed, my lords, because I am deputed for 5 years to the another department in order to
Closed.
relieve me.
Yes, yes, closed.
I am grateful to my lords.
I think it's done.
ಬರ್ದಿದ್ದೀರಲ್ವಾ? ಟೈಪ್ ಮಾಡಕ್ ಬಿಟ್ಬಿಟ್ರ ಅಂತ ಅವ್ರು ಕೇಳಿದ್ರು. ಟೂ ಲೈನ್ಸ್ ಆರ್ಡರ್ ದಟ್ಸ್ ಇಟ್ ಎಲ್ಲ ಹೋಗಿ ಗುಡ್ ಅಂತಾನೆ ಕಂಟಿನ್ಯೂಡ್ ಅಂತ ಬರ್ದು ಬರೀ ಅವಾಗ ನಾನು ಟೂ ಲೈನ್ಸ್ ಇದ್ರೆ ಬರ್ತಿದ್ದೀನಿ. ಅವರು ಏನೋ ಜಾಸ್ತಿ ಇದ್ದು ಅವಾಗ ಕಷ್ಟ ಆದ್ರೆ ಕರೆಕ್ಷನ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ಇಲ್ಲಿ ಬಿಟ್ಬಿಡ್ತೀನಿ ಟುಮಾರೋಗೆ 2 ಡೇಸ್ಗೆ ನಾನು ಅದಕ್ಕೇನೆ ಇಲ್ಲಿ ಸೈನ್ ಆಯ್ತಾ ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ ಏನಿಲ್ಲ ಸಾಕಾ? ಸರಿ ಬಿಡಿ. ಫಿಫ್ಟಿ ಟೂ ನಾವ್ ಹೇಳಿದ್ದು. ಹಾ ಹಾ 52. ಹೊಟ್ಟೆ ಹೋಗ್ತಾ ಇಲ್ಲ
ಇದೇ ಇಟ್ಟಿರ್ತಿದ್ದೀನಿ.
ಲಾಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ತೆಗ್ದ್ಬಿಡಪ್ಪ. ಒಂದೇ ಒಂದು ಫೈಲ್ ಮಿಸ್ ಆಗ್ಬಿಡುತ್ತೆ ಸಿಗ್ನೇಚರ್. ಯಾರು ನಿಮ್ ಸಾಹೇಬ್ರದ? ಇವಾಗೆಲ್ಲ ಸೇರಿಸಿ ಇದೆಲ್ಲ ಇತ್ತು ಇನ್ನೊಂದು ಆರ್ಡರ್ ಬೇಕಲ್ಲ ನೋಡಿ. 2167 ಶಿವ ಸರ್ ಆ ನಂಬರ್ ಹೇಳಿ. ಮಿಸ್ ಆಗಿ 2167 ಇದೆಯಾ ಅಲ್ಲಿ? ಈ ಫೈಲ್ ನೋಡಿ ಸೆಕೆಂಡ್ ಸೆಟ್ ಮಾತ್ರ ಇದರಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 52.1 ಇದೆ. ಮಿಕ್ಕಿದ್ ಸೇರಿಸ್ಕೊಂಡ್ಬಿಡಿ. 52.1 ಇದೆ ಮ್ಯಾಮ್. ಎರಡನ್ನೂ ಡಿಸ್ಪೋಸಲ್ ಬರ್ದ್ಬಿಡೋದೆ. ಒಂದು ಡಿಸ್ಮಿಸ್ ಆಸ್ ವಿಡ್ರಾನು, ಇನ್ನೊಂದು ಡ್ರಾಪ್. ಮೊದಲನೇದು ಇನ್ನೊಂದು ಡಿಸ್ಮಿಸ್ ಆಸ್ ವಿಡ್ರಾನು. ಮೊದಲನೇದು ಇಲ್ಲೇ ಆಗಿರ್ಬೇಕು ಸರ್. ಡಿಸ್ಮಿಸ್ ಆಸ್ ವಿಡ್ರಾನ್ ಎಲ್ಲ ಇಲ್ಲೇ ಇದಾವೆ. ಯಾವ್ದನ್ನು ತಗೊಂಡೋಗಿಲ್ಲ. ಇಲ್ಲೇ ಆಗಿರ್ಬೇಕು. ಫಸ್ಟ್ ಸೆಟ್ ಇಲ್ಲಿ ಇರ್ಬೇಕು. ಫಸ್ಟ್ ಸೆಟ್ ಎಲ್ಲ ಇಲ್ಲಿದ್ಯಪ್ಪ. ಎಲ್ಲ ಸೇರ್ಸೋದಷ್ಟೇ. ಇದೊಂದೇ ತಗೊಂಡೋಗ್ಬೇಕು. ತಗೊಂಡೋಗಿ ಇದೊಂದು ಇನ್ನೊಂದು ಅವರು ಟಾಪ್ ಅಲ್ಲಿ ಬರೀತಾರೆ. ಎರಡನೇದು ಡ್ರಾಪ್ ಅಲ್ಲ ಮೇಡಮ್? ಇದು CC ಇಟ್ಕೊಂಡು ಇದೊಂದು ಫಸ್ಟ್. ಶಿವ್ ಸರ್ ಇದು ಊಟ ಮುಗಿಸೋ ಬಂದಿದ್ದು ಕೊಡ್ತೀನಿ ಸರ್. ಅಪಿಯರೆನ್ಸ್ ಬರ್ದು ಕೊಡ್ತೀನಿ. 230 ಏನಪ್ಪ ಇದು ದೊಡ್ಡ ಬಳ್ಳು ಮಾತ್ರ ಇಟ್ಟಿದೆ ನೋಡೋಣ ಈ ಕಡೆ. ಇಲ್ಲಪ್ಪ ನಮ್ಗೆ
For us, my lord.
He will not. allow me
No,
to
no,
make
no.
submission.
Please,
Then
please, please.
for him to
My
say,
lord,
but
Just a moment.
please, please,
Yes.
please.
Yes,
Let my lord take his seat, man.
just a moment. What is the IA that you have filed?
Before that, my lord, I'll just in brief, what is transpired, I will tell my lord. Here, the appellant Rajamma, who is before the court, is represented by her power of attorney holder, that is her elder son Jagannath. Because coming to know that Jagannath is conducting against the interests of Rajamma, she appeared before the court on 25/2/20 before this honorable court. And at that time, intentionally, the Jagannath, that is so-called power of attorney, and his counsel both were absent. Then an order was passed. Srimati Rajamma, appellant, is present in person and submits that she will engage services of an advocate and seeks time. In pursuance of that, I filed an application I filed my wakalat on 10/3/2020. And I also filed an application that I have cancelled my the power of attorney which has been issued in my son's name. Therefore, I may be permitted to conduct the case on my behalf only. And also I filed an application for amendment of the cast title that the name of Jagannath be removed. And then all these proceedings started, and the so-called Jagannath files application stating that she is not my mother. And there was one another lady by name Rajamma, to whom the scheduled scheduled land has been allotted, and she has executed a power of attorney. And as is her power of attorney, he is conducting all these cases. And that Rajamma died several years back before filing of this writ petition. And in the name of a dead person, he conducts this case, saying that then also he produces the Xerox copy of the will, stating that she has executed a will and bequeathed that scheduled land to him. And all these are this one. And also he goes to the extent of filing application under section 495, 195 and 430 of the criminal procedure, code of criminal procedure, stating that I have instigated her and I am also a party in the fraudulent acts. And also he files an application on section 35 of the Advocates Act, stating that I have conducted the professional misconduct. One sufficient.
Now we understand the contentions between the parties. Now please tell us what are the office objections?
What are the?
What are the office objections?
Office objections, I have complied all the office objections, my lord. And I have also submitted in the office also.
Therefore, the matter now has to be heard. Before that can be heard, the office objections have to be complied with. Tell me what are the office?
Insofar as, my lord, office objection is concerned, that they have filed 3 memos, which office objection has been raised according to the cost title. I have filed, my lord, IA 1 of 2021 and, my lord, IA 1 and 2 of 2023. One is under 195 and one is section 35 of the Advocates Act, because earlier occasion same was conducted before the Karnataka Appellate Tribunal. Court has passed order and he has no any other, this Rajamma is, my lord, has made an memo before this honorable court through this advocate. Earlier occasion, my lord, KIT has passed order, she has no any right. I have produced additional documents before this honorable court. My IA.
Just a moment. Office objections on memo dated 2/11/2022 by filed by advocate for the appellant.
I have served the copy there. That
Copy has been
objection is
served. Yes, that objection stands compliant. Next, non-compliance of office objection raised on memo dated 3/8/2022, along with postal receipt having served IA copy to R3. You've been served with a copy?
Yes, I have sent a copy, my lord. That's also.
No, I have not received any copy.
He is not
Still.
R3, my lord. He is not R3.
Copy to R3 by a
Yes.
advocate for
That's
appellant.
also complaint.
That is compliant.
Yes, postal receipt is produced.
Yes. Yes, then 3 non-compliance of office objections raised on memo dated 9/12/2019 filed by advocate for R3. By the order dated 38/21.
That is
Index
R3T.
sheet to be filed, documents to be marked as true copy.
That's also R3D, my lord. Here, it is only the.
They've been complied.
Yes, ma'am.
R3D, how can he comply? R3D, he can't comply.
Here, the only point in his point is whether
AG Sivanna,
R.
correct?
Jagannath, who is the power
No,
of
why
attorney.
he is doing all these things, I can't understand.
Please don't speak at once.
Please.
Yes,
Yes.
yes. When I'm speaking, my land friend, allow me to speak. Otherwise, afterward, let him speak. I don't come in his way.
This is with regard to R3
Just a
deal.
moment. There is-
A.G. Shivanna, yes, he has given no objection. His office has given no objection, and some other advocates is appearing.
Shikant Prasad.
Yes.
Okay, Shikant Prasad.
Not present. Yes, that he has to comply.
Yes.
Never mind. Now, memo dated 26/8/2021 filed by advocate for appellant. It is no office.
Has to be ordered.
Yes,
Has to
those
be
No
ordered.
officer.
are to
Yes.
be considered.
Yes, then memo dated 1/9/22 by appellant.
To be considered.
Then recalling the order dated 25/2/2020.
That's
filed by-
IA itself that I have filed.
Yes, IA 1 amendment of memorandum of opinion.
Amendment, my lord, that I have filed objection.
Application, I have filed objection.
Yes. Deletion of name of power of attorney not ordered as yet.
No, no.
Deletion of name of power of attorney
No,
not.
no, not.
IA 2/22 to initiate criminal proceedings.
Yes, that is my, I have filed.
Now we have to consider.
Yes.
Yes.
Those are to be considered.
Yes.
Yes, let me submit. my-
My lord, insofar as, my lord, that this thing is concerned, my lord, on date may be fixed because, my lord, I'll file synopsis. And, my lord, have it day after tomorrow, my lord, this matter can be taken. And once for all, we can finish it off.
I don't have any objection, my lord. Only thing is my learned friend goes deep into the merits of the suit. Here it is not at all concerned. my lord.
Concern.
The appellant's concern is only to delete the name of the so-called power of attorney and allow her to conduct the case. And this Jagannath, who has made personal allegations against me, my lord.
That I will,
be present
I
before the
will,
court. He
I
just
will.
roams around the court.
No. He will present before the court. Next date, he will present before the court.
Let him
Whatever,
come
my lord, transferred
Let him
before
come
the court,
personally.
her affidavit, her husband name, her death certificate of original Rajama, everything has been produced before this court. That he has to say.
The appellant
On
is
that.
before the court, my lord.
Yes.
Let the Jagannath
Date,
appear-
yes,
before-
appear, he will appear, no
Yes,
problem.
yes.
Day after tomorrow
After.
for hearing on the IAs and the
Thank you.
memos.
Yes, much okay.
It's on day after.
Memo they have filed.
Please
That is,
serve
that did
copies
not
on-
be,
ಏನೋ ಒಂದು ರೆಕ್ಟಿಫಿಕೇಶನ್ ಮಾಡಿಸ್ತೀನಿ ಫೈಲ್ ಬಂದಿಲ್ಲ ಅವ್ರು ತೀರೋದ್ರಲ್ಲ ಅದಕ್ಕೆ ನಾನು ಹಾಕಿದ್ದೀನಿ ನಾನು ಮಾಡ್ತೀನಿ.
Please make available copies.
ಸ್ಟೇಟ್
State government at this
Please,
juncture.
please make it available, counsel.
ಏನೇನಿದೆ ಗೊತ್ತಾ? ಎಲ್ಲ
When you file an IA, copies have to be served on all the opposing counsel.
Yes,
It
my
does
lord.
not
Office
matter that
raises-
it is the state.
Office raises the objection and served also, my lord.
Please,
I will
please
contribute.
serve a
Yes,
further
I will
copy.
discuss with her and I will-
Yes. The learned counsel for the appellant shall serve copies of memos and IAs on the learned counsel appearing for the learned government advocate appearing for the state. This on Thursday,
Thursday of,
First
first,
August. Very good.
madam, my lord, maybe on fifth, my lord. Fifth,
Fifth
maybe on-
ಆಗ್ಬೋದು, fifth ಆಗ್ಬೋದು ಅಂತ.
fifth, August,
Fifth.
please,
yes.
much.
Sorry? Ah,
Yes, sir, that is, the order has been passed and so is your- but along very similar that it should be added. That the 23.1, 23.2 and 23.2.
After deciding this, whether who is Rajamma, then my lord.
then after that we can consider the, yes.
Chandranath Tarika.
For the appellant, my lords, I filed the amended appeal memo in the counter, my lord.
You have,
Yes, ma'am.
it is submitted by the learned counsel for the appellant that the amended memo of appeal has been filed. When was it filed?
Today, my lords.
Filed today. No, IA is for,
IA for
Filing
stay is
delay.
pending.
you've taken,
yes,
you've
delay
taken this
Yes, sir, already.
on all the respondents.
Yes, my lords.
145 days. What is this matter?
My lords, it's with an appeal, this matter, my lords, it's challenging challenging the judgment, order passed by his learned single judge, my lords, it has to be heard, my lords. It may be taken up in the next week.
Appeals are normally against orders passed. by
Yes,
the
my lords,
legislature.
it needs to be allowed, it needs to be heard, my lords. It may be taken up next week, my lords.
Yes. staff- Yes, heard, I gave for. Condoning delay of 145 days in filing this appeal. Heard the learning council for the appellant as well as learning, government advocate appearing for the respondents. In view of the permits made in the application. The delay of 145 days in filing this appeal shall stand condoned. This after 2 weeks.
So date may be fixed next week, lords. Great.
8th August.
Great.
25, government advocate.
Substituted service. What is the matter about?
This matter is reported to, this matter, a batch matter is pending here. This will also have to be collected along with that.
The first you have to serve notice.
Have to file an application to bring LRs on record. I pray for 2 weeks time.
Learned government advocate seeks 2 weeks time to bring the legal representatives of the deceased respondent on record. List after 2 weeks.
26, party in person, Y.N. Krishnamurthy.
Office objection raised on synopsis.
My lord, I would like to submit only few minutes, my lord. Then I'll come back to the office objection. In the last occasion, the coordinate bench, after heard the argument, directed both the counsel to file the written argument within a week before the 1 week of next date of hearing. Accordingly, to understand the legal position, I framed 4 core issues involved in the present writ appeal. Accordingly, I filed a written argument. For a moment, my lord, 2 seconds, kindly turn the page number 20 of the written argument.
Please first comply with the office objections without which
For,
we cannot.
for my side, for me, there is no office objection, my lord.
There appears to be a recalling order filed by party in person. There are several recall.
That is there is no office objection. There is a recalling order number 2 of 2023, 2 of 2024, 11 of 2022, and 10 of 2022. All the 4 IAS are heard, all the 4 IAS are argued before the honorable court, and thereafter the honorable court passed the order, directed to file a written argument to dispose the admitted writ appeal. If honorable court permitted me, so that again I repeating the same argument.
ಸರ್ವ್ ಮಾಡಿದಿರಾ ಅಂತ ಕೇಳ್ತಿದ್ದಾರೆ ನೀವು ಪೋಸ್ಟ್ ರೆಸಿಟ್ ಹಾಕಿದಿರಾ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಹಾಕ್ಬೇಕು ಸರ್ವ್ ಮಾಡಿದಿರಾ ಕಾಪಿ
Memo, that is not my, there is no my office objection.
It is my lord. My lord, the petitioner for last so many hearings, my lord, earlier also he has not given the address and he has also not given the mail ID. Now also this entire thing was sent by registered post, speed post. It is returned as usual. It is returned. Today, it is with me, my lord. If your lordship permits, I'll hand over it to now only, my lord.
Please hand over copies.
That
Yes.
synopsis as well as the written arguments.
Learned counsel for the respondent.
My lord,
Hand over copies of the synopsis as well as written argument notes.
Yes, my
To
lord.
the learned counsel, to the
my lord, 1 second. It is sorry for the disturb.
hearing in person.
Yes, my lord. Person, I'm giving my.
Yes. When do you want it?
My lord.
Matter can be heard today? Is the
Argument,
matter
my
to be
lord.
heard?
Yes, my lord. I have no problem, my lord. But only thing is, my lord, now another one objection is there, my lord, stating that second so cause notice was not served. In this regard, my lord, your lordship can kindly see I have filed detailed objection. Why it could not be served? That is on 8th April 2024. Your lordship may kindly see only 1 minute, my lord, that
Just
there.
please, not on the merits of the matter. Are you ready to argue? We can pass it over and hear it on merits. if the other matter.
My lord,
My lord, the respondent is misled the court because of the order is becoming in conflicting. Because of that, I filed an IA number 2 of 2023 and 2 of 2024. Both order are pending for disposal. If honorable court permitted, why he has misled to the honorable court, kindly permit me to make submission, my lord. Then thereafter, because the honorable court as in the coordinate bench, after heard the argument, then only the honorable court had directed to file a written argument. It is a complicated, they said. It's a misleading to the honorable court. My lord, once within 5 minutes, I'll finish the argument of IA number 2 of 2024 and 11 and 10 also. My lord, agreed by the order of the learned single judge, I referred a writ appeal. Writ appeal came to be admitted by its order dated on 9/6/2022. And in the writ appeal, whether fresh inquiry is permissible in the absence of specific rule for the terminated employee, and without deciding the fifth order of termination, inquiry report which is pending for disposal in the admitted writ appeal, and non-existence of relation between the employer and employee. Before deciding the issue on pleading and grounds and prayer of the admitted writ appeal, the counsel for the respondent filed an IA before the learned single judge. The learned single judge passed the order by extending 5 months' time, but it's order dated on 21/7/2022 without jurisdiction. And then thereafter, the honorable court division bench passed the order. The inquiry may continue and shall not pass the final order on the inquiry report. It is a matter of subject of judicial scrutiny.
Now the inquiry is complete and the report is here.
My lord, still the honorable court has appointed the retired district judge as the inquiry officer, which is pending for disposal. That is the questionable. That is I'm challenging.
Yes, we
It's
hear it from
a
you.
twice disposable order, my lord.
my lord, now, my lord, this entire, that second inquiry, my lord, as permitted by the honorable division bench, it was monitored by honorable division bench, my lord. Then the honorable division bench permitted the corporation to proceed with the inquiry. Then they said, don't finalize the report. Then after findings was placed before the honorable, honorable bench. Honorable bench, after going there, permit us to go proceed further in the matter. The disciplinary authority, taking into consideration all the factors, has imposed the punishment of removal from service. It has been served, and punishment has also, that punishment proceedings has also been given. So now, my lord, this writ petition cannot survive now, because the entire thing is over now.
The merits of the matter have to be heard. You're ready in the matter?
Yes, my lord. Ready is my lord.
Pass over, we'll hear it. Please wait. Yes.
27, Raghunath MD.
No appearance on either side. Not appearance. Wonderful. Yes. For recalling that order, no blame. Listens on that. No hurry.
28, K. Prasanna Shetty. For petition.
Maintainability. Maintainability.
Yes.
Lord, what has happened is, in this case, one Mr. Girish Jamgi was appearing. He is no more, my lord. Notice has to go to those.
We'll have to go again. Yes. It is submitted by the learning council appearing on either side that the advocate appearing for contents 1 and 2 in WP 2930 of 2023 as well as 2982 of 2023 and for R3 in 2983 of 23 has since passed, as well as in 2993 of 23 has since passed away. Please. And therefore, notice will have to be issued to the party. Yes, on the basis of that list. Just issue this. Responding. List after services complete.
Please.
Yes. That's different. 28.2. WP 2958/23, it is submitted by the learned counsel appearing for the petitioner, that the issue raised here is different from the issue which is being considered in the batch of petitions. Therefore, dealing from the list, from the batch and listed separately.
But wherever Girish Ejjamagi name is there, my lord,
Yes.
please, I'll take notice afresh,
Yes. You're taking out notice afresh to those respondents.
please.
Yes, list
Because I
immediately
inquired.
after.
His colleagues are also not there. I inquired. Let the notice go,
Yes,
please,
we have the list here.
please. Whether PF has to be paid, I'll pay.
Yes.
Other cases, PF has to be paid. In the lot 28, 28.7, 28.9, 28. I've made a list, my lord, wherever.
Yes, yes, wherever there is deficit of process fees, the same shall be made good.
Listed after
Yes.
service of notice. It may be listed after service of notice.
Yes,
Please.
list immediately after service.
Please. Oblige, ma.
In one case, there is steps to be taken in respect of a deceased.
This is
child.
R4.
Please
That-
do that.
that I'll, and one has to be dealt with, my lord, as my colleague told. Oblige.
29, Prashant HS.
Short accommodation.
And claimed R3.
Please.
Yes, unclaimed.
Unclaimed.
Held sufficient notice to the third respondent has returned unclaimed. The notice is therefore held sufficient. Then R2. Charge sheet. Who appears for R2?
Venkatesh Sarpet.
Fine. List it on some other day. You'll have it on some other day.
30, government advocate.
Appearance of the respondent, my lord. My lord, we filed an application for vacation of interim stay. I've filed the other copy this morning. If it may kindly be heard sometime this week or next, madam.
Next week.
Copy has been served.
2 sets of IA need to be filed.
List next week.
If a date may kindly be fixed.
Yes.
7th August.
Much obliged.
31, Sandesh Kumar.
Well, that's, with respect to the IA is concerned, some objections raised, but they will rectify.
Learning council takes time to rectify the office objections with regard to the IA. List after a week.
Yes, ma'am.
32, Manjula D. Please, ma'am.
In this case, my lord, in respect of seal, my lord, to in the Wakalat, my lord, there is no seal in respect of Mata Group Private Limited, my lord, but that company has been closed, my lord, already during the year 2019. That's why we are not put the seal. That is the office objection. Kindly overrule that.
The office objection may be overlooked for the time being, is overlooked for the time being. List after a week.
Kindly fix the date, my lord, please.
5th August.
Much.
33,
Any
Aniket.
council submission, the
Appellant, copy is being served to the trial court counsel.
Lords, I have copies received, my lords. I was been informed by the party today morning that he is engaging with the services of other counsel. So, my lords,
It's also posted today for furnishing security or show on. It's an application under 38 Rule 5 is.
lords, may I submit, my lords? I
Against
have
that
no
application,
instructions so far as this appeal is concerned from the claimant. Had it been, at least there would have been an oral instruction. I would have made submissions, my lords.
We'll have it tomorrow or day after.
Please.
My lords, the client specifically sent a message. I can show it to you.
The
Kindly have it in the
notice
next
has
week.
has otherwise also been taken.
Please,
Yes,
sir.
yes, yes.
It's also permitted. See this week. Yes, list on Friday.
I'm grateful.
Learned counsel appearing for the respondents admits that he does not have instructions to appear in the matter. List on Friday.
2nd August. 34, Anand HC.
What is the council submission? 3 to R6 and R9 are not parties in claim petition.
Furnishers around 3, 4, 5 are made parties, however, they are not parties in the cost rate liability.
Where is the council? Appearance staff 2 weeks.
35, Nanjare DPN. Color photograph.
What is the color photograph about? Color photograph in a service writ petition? Weeks time to comply. Photo itself is not required. Why color photograph? Dispense, office objection is dispensed.
36, Sagar BB.
For the Officers Council.
Yes.
Given is seeking for dispensation, my lord, I have already given the translation copy. Kindly grant 3 weeks, my lord, more than 100 pages are there. So far as the other objection is concerned, additional documents, copy is served to the government advocate. Government advocate is the only competent, my lord, contesting respondent. For translation, 3 weeks may be granted.
Yes. 3 weeks time granted to comply with the office objection. Regard to production of
The
translation.
other objection may kindly be overruled.
Yes.
Please.
37,
For the petitioner,
Anpurna.
Lordship, he's been reported to the duty in the month of May. Producing a copy of it.
English translation.
And it's been
Nothing survives?
nothing, my lordship. He's already reported in the month of May and he's been serving in the same.
It is submitted by the learned council for the writ petitioner that
My lordship.
you have reported for duty.
Yes, my lordship.
That the petitioner is reported for duty in the transfer place and nothing survives for consideration. The submission is taken on record. The writ petition is closed as having to come for this.
Great.
Thirty-eight, Vijay Kumar.
Only translation?
Vijay Kumar.
Only English translation, nothing
Yes,
else?
yes.
What is the issue?
But the issue is, my lord, the petitioner was appointed as full-time sweepers. But they were initially paid through contingency fund. But they approached the tribunal seeking for time-bound advancement and automatic grant of promotion. That application was allowed. But the state preferred a writ against that. That writ was dismissed. Thereafter, my lord, SLP was preferred. That was also dismissed. Now, my lord, he is being paid, he was paid the automatic grant of promotion and the time-bound promotion, and his pay was refixed. But on 2/7/2013, initially, my lord, his pay was being paid under the contingency fund. But unless I challenge that, they could not have regularized. Now the KAT has rejected my application on the ground of delay and laches.
Yes. You have copies?
Yet to receive instruction.
Learned government advocate takes time. Takes notice for the respondents and seeks time to get instructions. This after 2 weeks?
Please.
39, PM Nayak.
My lord, for petition, my lord, office observations, my lord, the relevant documents, the sub-page was given, my lord.
What is the matter about?
Matter about, my lord, the petitioner is retired from service during 30th/6/2018. After 2.5 years, my lord, charge memo was issued under KCS CCA rules, my lord, which is impermissible, my lord, because once he retired, the rules are not operative for the retired government servants, my lord. And
The provision in the,
no, KCS CC rules are not operative to the retired government servants.
There is a-
Only government can initiate the inquiry under Rule 2014 of the KCS, sir.
214.
Yes,
Yes.
here it is not the case. Here they have issued the charge memo, annexure A2, and moreover, a first respondent is the incompetent authority. He is the chief CEO, he is not the government. Under the same decision, my lord, it is challenged, my lord. Initially, the KAT granted the stay, my lord. My lord, then final order, my lord, KAT comes to the conclusion there is no prejudice caused to the applicant by petition, my lord. Until it is incompetent authority, is not empowered to issue the charge memo.
should notice to the
Stay, I sought the stay of the.
respondent. Speak first. Learned government advocate accept notice on behalf of the second respondent. What was the post held by you?
Assistant Director of Agriculture,
How can the chief executive officer issue?
not within his jurisdiction.
Yes. Further proceedings against the petitioner shall be kept in abeyance till the next date of hearing.
Stay, I can apply them.
Till next date.
40.
Appear for the petitioner. My lord, in respect of respondent number 7 and 11, I may be permitted to delete them because they have been superannuated from service, my lord.
Government counsel for the petitioner submits that notice has not been served on respondent 7 and 11,
11, my lord, 13th, I'll take hand summons, my lord.
and that they may be deleted from the party array since they have retired from service. Respondent 7 and 11 are deleted from the party array at the risk of the
Please, ma'am.
petitioner. Petitioner shall serve notice on R13 by hand summons.
My lord, there is some urgency, my lord. I have filed an application. My lord, on 11th of June, your lordship may kindly direct the registry, my lord, to put up that application.
That's one submission on behalf of respondent number 5, my lords. Respondent number 5 is Department of Ministry of Law and Justice, my lords. Because they had arrayed as a party, respondent number 5 before the tribunal. Here also they have arrayed. No, it's actually, it is the Department of Personnel and Training, which is the proper party. It's left to them, my lords. My
Be
submission.
better that the learned counsel appearing for the fifth respondent submits that the Department of Law and Justice has been impleaded as R5 in this writ petition. It is contended that the proper party would be the Department of Personnel and
Training, my lords, DOPT.
Personnel and Training.
My lord, the DOPT has no say in the matter. My lord, this is a state cadre. My lord, it is the law and
Submission,
justice.
my
my
lords,
lord.
if they want.
Submission is on
That's all.
record. You can take your, if ultimately it is found to be so, then
My lord, they are formal parties because, my lord, I have challenged the amendment, my lord, to the criminal procedure code. I have implemented law and justice. DOPT has nothing to do with this, my lord.
yes,
My submission may be recorded. That's all, my lords.
yes.
Please. Much of.
My lord, I have
So-
filed an application, my lord, on 11th June. Your lordship may direct the registry, my lord, to put up that application.
Yes. Submitted why is it not being put up? It is submitted by the learned counsel for the, no, that,
Actually, the 2 of 24, I gave the steps need to be taken.
yes.
My lords, could the submission of the learned counsel that I am formal party, could it be recorded, my lords? So that if anything happens.
My lord, they are formal parties, my lord.
His submission. my
Takes
lord.
the risk when you
Stay
when you
application.
say that
stay
you are
on.
not the proper party
They come
and
up
they
with-
do nothing about it, they take the risk.
Please.
Yes,
My lord,
list the IA, list all IAs.
my lord, next week, my lord.
R13 has to be served
I'll serve it, my lord, in 2 days, I'll serve.
next week.
Much.
9th August. 41. CH-3 ra.
All of his objections,
Translation. Text to be staged at pagination.
all the English translations have been done, lords. The translations have been done.
Is there any other office objection?
IA 1 of 24 to prior to be
There is-
clarified. Advocate.
If there is any,
sign
please
the index
comply.
of second set.
We'll
All
list
the,
it on
lords,
any
the
other date.
remainder has been done. The remainder has been the first, it is the second round of office objections which were raised. Lords, the urgency was this, lords. because of my child's ill health, I was transferred to a place where my husband was working. The private respondent challenged the same before the Service Appellate Tribunal, claiming that there was no counseling done. Just in order to bring your lordship's attention, running page 16 for a moment. This was the only list of ENT surgeons who were involved. Then, amongst that, even if counseling was held or not held, the position between the current petitioner and respondent number 4 would not have changed. On that ground, previously also, when my
And in the current counseling,
current counseling has not yet taken place. Current counseling has not yet taken place.
the specialist counseling, only the mismatch has happened.
It has not taken place. For one moment, 16 minutes, my lordship, if it could be perused, there could actually be no change at all, even if there were to be a counseling. There were only 4 ENT surgeons.
Even if whatever you're stating is correct, notice has to be issued. Notice has not gone.
Notice has not gone. Now, by effect of the impugned order, now what happened was, my transfer order was stayed in the interim by the KAT. That order of stay was assailed in a writ petition on the file of this honorable court. In that writ petition, the order of stay was stayed. And the KAT KSAT records a order stating that subject to the writ petition, we will take up the matter. Somehow, there was a batch of these matters which came up before the KSAT. And this was also, the original application was also disposed of. Leading to the order of transfer being set aside on the ground that there was no counseling effected. Now, on the basis of this order, if I'm sought to be transferred away, my child suffers from a immunogenetic disorder, it's called Kawasaki. And the parents ought to remain in the place, and both of them are doctors.
How old is the child?
Currently, it's around 3.5 years.
Give instructions.
3.5 years.
Petitioner.
I'll serve a copies of
Serve a
to my learned.
Yes,
A
serve a
date
copy
be-
and please see that the.
I
outcome
shall,
of the
I
objections
shall.
are Complied.
If-
Learned counsel for the petitioner to see that the office objections are complied with. And serve a copy of the petition of the learned counsel, learned government advocate appearing for the first respondent. List day after tomorrow.
Grateful, sir. Grateful. I'll do the needful.
42.
For petitioner, my lord, one of the office objections, my lord, advocate welfare stamp, 20 rupees has to be paid. I'm sorry, my lord. Along with the IA, it is not.
We are thankful that you're not asking for 3 weeks' time.
I'm sorry, my lord. And other two objections, my lord, the reply filed by the government before the KSAT is not produced. That may be kindly be dispensed with, my lord, for the time being, because it is not available in our file.
It was not available in your file.
Yes.
It probably is available when the file comes to him. Yes, let's see. Yes.
Anyway, they are also, my lord, supporting the petitioner.
Learned
before the
counsel
KSAT.
for the petitioner seeks short time to comply with the office objections. The objection with regard to the reply, non-providing the copy of the reply is overruled for the time being.
Please, and.
If it is required, if it is.
Please, definitely, madam.
Please see that it is.
And translated copies also of the annexed.
Learned counsel for the petitioner submits that necessary translations of the required documents will be made available at the time of hearing. When do you want it?
Next week,
This next week.
please.
9th August.
Apply. Please.
43. Vijay Kumar. Legible type copy of A711.
While the translation copy, my lord, and legible typed copies, my lord, I'll furnish it, my lord. Matter relates to, my lord, I was only seeking for a direction to consider my claim for promotion against a backlog vacancy. Now, tribunal goes into the report submitted by the Social Welfare Department, which was never under challenge, which is competent to, my lord, submit a report regarding the backlog vacancy. And comes to conclusion that it is the DPR which has to decide who has to decide regarding the identification of backlog vacancies and dismiss my application.
Matter has come up for the first time. Notice me.
Yes,
Get in.
notice.
Please.
Notice to the respondents. As we post, in the meanwhile, the office objection shall be complied with. List up.
R4.
R4, learned government.
R4
advocate
is, he was one of the applicants, my lord. He is not challenging the order. He's only a formal party.
Anyway, let notice be
Yes,
taken to R4. Learned government advocate takes notice on behalf of the other respondents list. After 3 weeks,
Yes,
44, Nanjara DP.
I appear for the petitioner. That is the only objection.
respondent number 3 and 4. Who are respondent number 3 and 4?
3 and 4 are not necessary parties.
Not necessary.
Not necessary. I filed a memo also. Millard, at page 5, I have stated that it's not necessary. No relief claimed against them.
It is submitted by the learned counsel for the petitioner that no relief is claimed against respondents 3 and 4.
Legible.
So they are not necessary parties in the petition.
Next objection.
Yes.
Next objection that there is a legible copy in that I protest. It is legible in that page 31, 36.
Yes, the rest of the office objection shall be complied with.
No,
Yes.
that is the only objection.
Nothing
Next
else.
one is
English translation, the usual.
Index and pagination to be checked.
Please
I will
do the necessary. We'll have it next week
yes,
for admission.
yes.
We'll comply with the other
It's only,
objections.
I will comply it here.
Yes. Is listed someday next. 13.
These compulsory retirement, Lordship can order notice.
This can go?
Notice.
Yes, then
First respondent blood is the,
no requirement to,
Government.
the other office objections will be complied with immediately within 2 days. Issue notice to the,
R2 Lokayukta.
R1 government, R2.
yes, the
Please.
government advocate takes notice for R1.
Let-
Issue notice to R.
That's seal number 35, I'm sorry. I could not appear. Color photographs, they are not necessary in that. It last may dispense with.
Yes, we have already dispensed.
I will place.
45. Raghavendra N. Court fee to be.
Court fee. 1 week to comply.
Satish K.
46. English translation usual order.
That is the only objection.
What is the matter?
Matter pertaining to not transfer. The petitioner was working at Holenarsipura.
Hmm.
That is in Lord Hassan district.
Hmm.
Lord, while working at Hassan, my lord, I was posted as District Skill Development Officer, Mysore, on additional charge.
Yes.
Lord, I took charge at Mysore on 19/9/2022.
Yes.
Lord, on 28/2/2023, while working as Lord District Skill Development Officer, Mysore, I am regularly posted there on 28/2/2023.
Therefore, your contention is that it is from 28 to 23 that the tenure has to run. No.
My contention is that Lord, it is to be counted from 28/2/2023. Lord, even otherwise, my lord, even if 16/9/2022 is taken into consideration, Lord, I am entitled for 2 years.
Hmm.
Lord, the impugned order is dated 10/11/2023. Lord, the second respondent is 2 cadres below the cadre of petitioner. Lord, petitioner is in the cadre of Joint Director of Employment Training. The second respondent is in the cadre of my lord Assistant Director, which is 2 cadres below. 10/11/2023. The second respondent is posted to my place. I am posted to Srirangapatna. Lord,
Reasons?
no reasons are assigned. Lord, as an officer, my lord, I should bring it to your lordship's notice. Lord, the stand of the government is, my lord, the district skill development officer can be held by any officer of Group A. Lord, the second respondent is also a Group A officer. Lord, this goes against me.
Hmm.
Lord, on that ground, my lord, the tribunal rejects my application.
Hmm.
It is premature. Lord, I am at the verge of retirement. Lord,
When do you retire?
in 2026, my lord.
Yes.
And there is a circular,
Now if you are transferred, probably that is available to you.
please,
Now if you are transferred, probably the ground of retirement may be available.
even then, as on 10/11, my lord, it is 2 years. 2 years, my lord.
10, 11, 23, you won't get it because
Lord, I am going to retire on
if it's 26, you won't get it.
Lord, I'm sorry, my lord, I'll tell the exact date.
If it's only before November 25 that you will get it.
Not September 2025.
Yes, you're covered.
I'm covered within 2 years.
Yes,
Lord-
no reasons at all.
Please,
No reasons.
no
at all.
reasons. But the tribunal's finding is that he is eligible to hold the post. Not, he is in the 2 cadres below the petitioner. However, not government order provides for holding such officer. Therefore, my lord, the transfer is permissible. But for premature, my lord, reasons are to be recorded. Not I had throughout, my lord, I had the benefit of interim order, not the tribunal's interim order. After not recording reasons, my lords may kindly come to my lord, page 97. All these, my lord, contentions are noted, and the tribunal passed a detailed order, and
You've been relieved.
no, my lord, as on today I am working. Page 97. Learned counsel for the applicant states that applicant is in the cadre of District Skill Development Officer, Department of Skill Development. So initially he was posted on additional charge on 16/9/2022 as per annexure A6 and reported to duty on 19/9/2022. Subsequently, he was regularly posted by order dated 28/2/2023. In addition to the post of so-and-so on his own pay scale, he states that the word used in his own pay scale is misnomer in view of the fact that he is holding equivalent grade, and thereafter movement order is issued reported to duty on 10/3/2023. Now by order dated 10/11/2023, the second respondent who is in the cadre of assistant director is posted.
Just a moment.
Please.
Regularly posted by order dated 28/2/2023.
Yes, ma'am.
In addition to the post of principal of government training institution on additional charge.
But in addition to Hale Narsipura, I am regularly posted
Here as well.
as my lord, Mysore. Now, my lord, that charge went.
That
I am
applicant
working
is a
only in
regular-
Mysore.
Applicant is a regular holder of the post of district skill development officer while he was working as pays an additional charge of the post of district skill development officer. Now by order dated 10/11/23 by posting a person who is not eligible to be posted, who is working in secretary is posted.
The eligibility concerned, my lord, I cannot press. Now, my lord, the state has produced the order. Insofar as premature is concerned, my lord, that ground is available now. Eligibility is concerned, my lord, the state has filed the reply which indicate
What is the finding of the tribunal?
tribunal, my lord, yes.
Final.
My lord, final page 34, it starts.
Hmm.
That is the only finding, my lord.
48.
Yes,
Applicant is urged the order dated 10/11/23 issued suffers from infirmity. What is a premature displacement?
page 50, my lord, the tribunal says that the government order which enables a group A officer to be posted, therefore anybody can be posted there. The tribunal does not consider whether my lord, premature or not. Even now, my lord, it is premature.
Further, the impugned order has been issued after obtaining approval of the chief minister as required under government order dated, which regulates the transfer of government servants, which indicates that the respondents have followed.
Reasons to be recorded, my lord. Chief minister's approval is there, my lord. I am not saying that, my lord, there is no chief minister's approval. Approval is there. but reasons to be recorded for premature displacement.
From Mysore to Srirangapatnam. What do you say?
But
What is the distance?
Mysore to Sri, it's nearby.
Very, may not be, my lord, 50 kilometers, it may be 50.
16,
Very close.
16 is what my brother says.
16 kilometer, Google now check ಮಾಡಿ. 16. 16 kilometer.
So
Even then, my lord,
we'll consider it on the merits and the, that
But
he's
I-
going to retire. Why should there be a disturbance at the last fag end? But it's very close.
but I had the benefit of interim order. Your lordship may,
But if he has not, I don't know if he has been relieved or not.
If not relieved,
Yes.
Status quo may be made. Status quo as on.
your lordship may say, if not relieved, my lord.
to R2. First. Issue emergent notice to R2. In view of the submission made by the learning council for the petitioner, that he has less than 2 years to retire from service, and that he is undergoing treatment at Mysore. There'll be an interim direction that in case the petitioner has not been relieved from Mysore pursuant to the order dated 10/11/2023, he will not be so relieved and shall be permitted to continue in Mysore till the next date of this. If not relieved,
Yes, if not relieved.
government advocate takes notice for R1, seeks time to get instructions. List after 3 weeks.
47. Sankesh A. Bora.
47, my lord.
Yes.
Appears for the petitioner, my lord, only regarding translations, my lord. One, two impugned order and another order which are relevant, I have translated and given, my lord. Matter relating to, without amending the cadre recruitment rules on the basis of executive order, they are trying to give promotion, my lord. Whereas in one of the commissionerate, they have given promotion according to the existing C&R rules. So far as Bangalore commissioner is concerned, they are not following. I challenge it, application has been dismissed, my lord. Matter is of urgent, my lord. Therefore, respondents number 1 to 3 are government directed take notice, my lord, and a short date may be given for consideration of interim order. Today, I am not asking, let them give a short date and all.
All arguments are taken note of for the next item.
And that's what, my lord, the notice maybe direct government advocate may direct it is 1 to 3, so that he
Lord,
can
sir,
be
we are
ready.
at serial number 47.
47, my lord, mine.
Then in 48.
Sorry.
Yes.
Sankesh A. Bora.
Any representation? Weak step. Yes, 48, we have heard you. Yes. The office objections are,
1 to 3, my lord, are government respondents.
yes, are dispensed with for the time being,
Yes.
overruled for the time being.
Next week for consideration of
Government
interim
next
order.
week takes notice for respondent 1 to 3. List after 10 days.
Please.
Yes, yes.
ಎಲ್ಲ ನೀವೇ ತಗೋತೀರಾ? 49 Satish K.
Only English translations.
Only translation, not the matter pertaining to, my lord, the departmental inquiry, not held against the petitioner. Not the allegation against the petitioner is that, my lord, petitioner while working as, my lord, the inspector of legal metrology, lord, at Karwar, he has demanded, lord, illegal gratification in the form of, my lord, mobile set.
Yes.
Lord, I had the preliminary objection for initiation of inquiry is that, Lord, the observation note issued by the inquiry officer is contrary to section 9 of the Lord Lokayukta Act, and in the teeth of Lord the principle laid down by this honorable court in Lord Somashekharappa's case. Lord, the observation is at page 89. Page 89 is the observation note. Lord, the is issued by my lord additional registrar of inquiry 6. Pursuant to that, my lord, I have participated. I have raised objection, but Lord, I participated. Lord, the inquiry officer ultimately, my lord, holds that, Lord, the mobile set is recovered from my table,
Yes.
which is in the form of, my lord, the illegal gratification.
In connection with seizure of 6 mobile set, namely so and so.
Yes,
so,
ma'am.
so, from mobile and electronic goods shop of complainant.
Once Samsung new set was demanded,
You have asked him to come and see you, respond to bills of said mobiles. Contacted at your office, inquired. Pay penalty. Up again in the first reading. Some other good mobile set has to be given by.
Lord, I was the inspector of legal metrology,
Yes.
had raided his shop,
Correct.
mobile shop. There, my lord, certain mobiles were seized, which were without bill. Lord,
Yes.
this, my lord, observation note is issued by additional registrar of inquiries. Lord, the coordinate bench of this honorable court has held that, my lord, the observation note cannot be issued by any officer other than Honorable Lokayukta or Uplokayukta. The language employed under section 9 of the act, which is mandatory in nature, and my lord, the such statutory function,
How does the tribunal deal with that?
but tribunal has not considered that, my lord. Tribunal says that, my lord, no prejudice is caused, at page 10, my lord. Page 10 of the judgment, my lord, rendered by, my lord, in Basavaraj's case. The tribunal, my lord, says that the evidence cannot be gone into in the departmental inquiry unless it is a case of no evidence. The penalty can be interfered with. Otherwise, my lord, there is no scope for the finding of the tribunal is at, my lord, page 49, 48.
Looking to the inquiry officer's report, it is dated 31/3/21.
Yes,
Used as A9. Side of dispute authority, 3 witnesses were examined, PW 1 to 3, documents P1 to P18 were marked. On the side of the defense, no witnesses were examined nor any documents produced. So it goes to show that the applicant here, and though he defends that he has not demanded accepted bribe amount of payment. So and so is being stated in the explanation which is given immediately after trial proceedings at least to support this contention or to have entered the witness box to give evidence. Perusing the inquiry officer's report and filing notice.
Then, my lord, tribunal says that page 59. It is not a case of no evidence. sufficiency of the evidence cannot be gone into by the tribunal. And
Similarly, the oral evidence of PW2 complaining that the examination chief also supported his version, deposed in detail about going to Lokaयुkta office, giving complaint, producing so and so. Denomination of notes is spoken about. Hand wash of the DGO. Not that it is, this aspect, had you raised it before the tribunal?
yes, Lord, your lordship may kindly come to, my lord, the judgment of this honorable court. Straight away, my lord, the page 11, para E. Page 11, my lord, para E. The text and context of section 9 make it clear that Lokayukta Uplokaykta shall hold or cause a preliminary inquiry and thereafter decide as to desirability of the investigation into the matter. When he forms an opinion on the basis of preliminary inquiry that there is a case for investigation, it is he who shall forward a copy of the complaint to the public servant and also to the competent authority concerned. The public servant shall then have an opportunity to offer his comments on the complaint. This is the legislative scheme, and an otherwise interpretation would bruise it to the prejudice of the delinquent public servant, to say the least. As already discussed, the provision imposes a duty upon the Lokayukta or Lokayukta to apply his mind to what emerges from the preliminary inquiry and only then to take a decision. This duty is not discharged when an officer of a preliminary inquiry forwards a copy of the complaint to the public servant. If the legislature intended that copy of the complaint should be forwarded by the officer of a preliminary inquiry, that there is no such requirement que Lokayukta, the text of the provision would have been different. On that ground, my lord, matter was remanded to do de novo. But apart from that, my lord, it is not recovery of currency notes here. It is the recovery of, my lord, Samsung set.
There is also some currency notes.
Not
3,000.
currency notes. Currency.
Para 11.
Yes, it appears, because I just read 3,000 by which.
No, that is,
So
my lord,
that is the penalty.
penalty
Is the
which
actual
I have to impose.
That he pays, and apart from that, he also hands over mobiles.
Not this 2,500 referred is a penalty.
There again, there is a problem. Please see the charge.
Yes, ma'am.
By way of penalty, you asked him to bring 3,000. He brings 3,000. He had given Samsung mobile set, and the penalty, some concession is to be shown at the time. He asked the complainant to pay 2,000. But DGO told the
3,000 towards penalty, ma'am.
his minimum penalty is 2,500. Therefore, he told that he will adjust there is no allegation that you took the 500. You
But-
reduced 500, that is all.
My lord, I have accepted the bribe in the form of Samsung mobile set.
It doesn't always have to be in the form of currency.
Money.
It can be anything.
But
Well, I've heard long ago in rural areas, bribe used to be in the form of vegetables and fruits. Therefore, you have to be careful even of that.
But penalty of 40% of pension permanently is imposed. I had the benefit, my lord, I leave to the court. Initially, my lord, page 199, tribunal had granted interim order, which was page 199.
Day of June 2020.
110/2022 is the impugned order, page 190. Interim order is at page 199.
What do you say
The
about
trap
this?
appears to have been proved, my lord.
What do you say about this judgment? It says that it has to be forwarded by the Lokayukta or the Upalokayukta, not by the registrars.
But Haven't had time to look at it, my lord. I'll examine that and make myself,
Please.
because the matter has come for the first time.
Yes, Learned Government Advocate seeks time to get instructions. Just on Friday, only on this point. This is so we'll have to consider this on the minutes.
Please.
Friday.
The judgment.
That time nothing will happen.
Yes, ma'am. Even single side is there.
Please serve a copy on the Council for the
Yes.
Local Thoughts. $50.
Not
15 in there.
not the petitioner is in the cadre of Lord Inspector of Police. Lord, he was posted to Lord Civil Rights Enforcement. Lord, there were certain FIRs which were registered by Lord different police station, which was transferred to Civil Rights Enforcement. Lord, the Civil Rights Enforcement is a wing which Lord, a special wing constituted for Lord, the investigation arising out of Lord atrocities, Prevention of Atrocities Act.
Correct.
Lord, the FIRs were registered, transferred to Lord, the enforcement wing. Lord, those FIRs were challenged before this honorable court by Lord accused. This honorable court in all the three FIRs, stay was granted. But Lord, I would concede for a moment that in two of the cases, Lord, I am the investigating officer.
Yes.
Lord, the allegation against the petitioner is that, Lord, I have not investigated those Lord FIRs is the allegation. Lord, which are stated by this honorable court. If I investigate, Lord, it amounts to Lord contempt. The annexure A4 is Lord one stay order, A5 is another stay order, A6 is my lord.
What is the date of the orders?
Yes, the date my lord interim order is 16/2/2023. First FIR.
Yes.
Not second FIR is dated 6/11/2023.
Yes.
Not the third FIR is 1/9/2022. In respect of not two FIRs, not I am the IO. Another FIR, my lord, it is transferred to some other IO. But the I challenged, my lord, the on that ground, my lord, I am placed under suspension. Lord, annexure A15, page 90 is the order of suspension. Lord, the order is passed by Additional Director General of Police. Lord, in respect of the same issue, Lord, the competency of ADGP to place the Inspector of Police under suspension, Lord, coordinate bench of the tribunal, Lord, has held that ADGP has no jurisdiction to place a police inspector under suspension. Lord, may I request my lords to have a look at my lord page 115. Lord, it is the judgment of my lord the tribunal.
Just a moment. On 17/5/24, crime review meeting was held. Crime number scrutinized, no action has been taken in the following cases. Crime number 87/22, Devanali Police Station, dated so and so. Interim order is subsisting, which is granted by the Honorable High Court in the said case. Same is not vacated.
Lord,
Crime number 292/23, Nelamangala Police Station, interim order granted. Same is not. Therefore, they are aware that there is an interim order.
Lord, thereafter, Lord, of course, Lord, I would say that, Lord, I have not filed IA for vacating stay. But at any rate, Lord, interim order is operating against the state, which they are aware. Lord, page 115 for a moment, Lord, the tribunal's order.
Just a moment. The above charges have been considered main object of creating said directorate to provide justice to deprived scheduled caste, scheduled tribe people has been compromised. Investigation has not been completed with the. Yes, what does the,
Lord,
what does the?
The
tribunal-
page 115.
Yes.
Tribunal has held that, Lord, the page 124, my lord. Order was again passed by my lord, ADGP, Additional Director General of Police, page 124, para 6. It says that, my lord, the Additional Director General of Police is incompetent to pass an order of suspension. Page 126. Another order is at page 128. The tribunal says that, my lord, he is incompetent to pass an order. My lord, when I urged this ground,
Just a moment, though the learned counsel is not produced amended rules, I've gone through the amended rules also to the schedule. Amended rules in that regard, notification by government. Schedule. So authority empowered to make the appointment to the officers of the rank of IDGP, DIGP, therefore make appointments to the officers. Police commissioner is not at all mentioned as appointing authority for inspector. The police commissioner is in the rank of superintendent of police. This
Additional
is
Director General of Police.
Additional director.
Yes, he is above.
But it is,
No, the tribunal says, not I am on a against the interim order. Tribunal, not learned, my lord, administrative member, by way of an interim order, says that, my lord, those judgments are per incurem, does not bind us and rejects the interim order.
that does it say?
Lord, yes, Lord, page 27.
In column number 4 of the schedule of.
Para 7.
Rank of superintendent of police and deputy inspector general of police to whom the police officer was subordinate. At the time of taking action under the rules are also officers who are competent to place a police officer under suspension.
In the instant case, applicant has been placed under suspension by an officer superior to the appointing authority of the applicant. Hence, contention of the so-and-so suspended by an incompetent authority lacking in jurisdiction to place the applicant under suspension is untenable in law. In application number, these orders are, my lord, which I showed it to your lordships. By a single member bench of this tribunal, the finding that Commissioner of Police, who is undisputably above the rank of Deputy Inspector General of Police, is not competent to place a police inspector under this charge on suspension is a judgment rendered per incurem, not by way of interim order, in which there is no reference to the rules and the relevant rule too has not been discussed. In the instant case, the authority who has suspended the applicant is an officer rank of Additional Director General of Police who is undisputedly superior to the appointing authority who is deputy.
What is the language of the rule?
Order.
Rule says any authority to which the appointing authority is subordinate.
Yes,
Position.
notwithstanding that, but can tribunal, my lord, by means of an interim order, say that, my lord, those final orders are per incurem and rejects the interim order?
That may be
My lord,
correct.
proper course according to me, my lord, would have been, my lord, to grant an interim order and differ by means of a final order. But how tribunal can differ by, my lord, can declare in an interim order that those orders are per incurem?
Yes.
And my lord, interim order is operating against me at the hands of this honorable court. Can it be a ground to place me under suspension? Lord, I'll argue on that. But
That point we can,
my lord, tribunal rejects and says that I will not consider.
as a matter of fact, unless there is a finding that he has not done anything to vacate the interim order or that he has failed in his duty, can the fact of an interim order passed by this court be a reason to place an officer under suspension?
Lord, may I get instructions because the allegations are quite serious.
Yes, learned.
Maybe taken up next week.
Government
But
advocates
your
need time
lordship
to get
may
instructions.
grant interim order, my lord, till
This on
Next Tuesday.
this next Tuesday.
your lordship may not.
In the meanwhile, he's already out of service as at present. This will be a positive direction because right from the, when was the order of suspension?
The June order of suspension is
25th June month.
25/6.
Have it on Tuesday.
The one difficulty is this, my lord. The matter will be listed tomorrow. On that day, my lord, tribunal will not grant interim order. Tribunal will not grant time, my lord, for final arguments.
You can,
We are considering it on the merits of the matter.
Even then,
matter will be considered on merits, then it is good for him.
If it is considered on merits also,
writ petition will be rendered infructuous, my lord.
It is only for an interim prayer before this honorable court.
But against interim order I have
Against the
come. But
refusal to grant interim
My
order.
lords are, my learned friend is aware.
suppose the,
Tribunal will not give time, lord, when I say that writ petition is filed.
suppose the tribunal hears the matter and holds in your favor, saying that because let's have it next.
Chances are-
Let them get instructions in the matter.
But
This,
may I
this
request, my lord, in that event, my lord, day after,
Friday?
day after tomorrow, my lord.
Thursday,
Friday, ma'am.
Friday. Yes.
Friday. I'll get instructions on Friday. All right. Only having regard to the seriousness of the allegations.
But even so, when there is a stay operating as against the.
I understand.
Because what you have stated in that order appears to be that he has not investigated it.
He could not have investigated because of this. That I'll examine.
Yes, Friday.
Thursday,
Friday.
Thursday early.
Friday, ma'am.
Friday ಇರಲ್ಲ ಅಣ್ಣ.
Till number 26, passed our matter. Party in person. Krishnamurthy.
My lord, in this case, I want time, my lord, because my eyes are not well. I'm taking treatment. Want clear.
Can we hear the
Yes, my lord.
petitioner?
Yes, yes, my lord.
We'll
Yes.
hear you on another day.
Yes, my lord.
Let
Yes,
him
my lord.
complete his argument.
Yes, my lord.
Yes. Make available the synopsis also. You've made it available? The
Yeah,
synopsis?
clearly mentioned in chronological order, synopsis, written argument.
Yes.
It is better for written argument in synopsis, my lord. My lord, I challenge a portion of the enquiry report regarding recommend to the disciplinary authority appointed by the court appointed by the enquiry officer. And before that, I would like to mention only few words. My lord, I was appointed as sales officer in Karnataka Silk Industries Corporation in the year of
Just a moment, appointed as?
assistant sales officer in Karnataka Silk Industries Corporation.
Yes.
And thereafter, I was discharged from the service after 7 years.
Discharged, by discharge, you mean your probation was never declared?
The probation period is not declared. And subsequently, I agreed by that order, I preferred a writ petition. In writ petition came to be rejected, it is not a stigmatic order. Against that order, I preferred a writ appeal.
Yes.
In writ appeal number 1991 of 1994.
Yes,
In the division bench, there was a different views.
yes.
Then the honorable Chief Justice agreed passed the order.
Yes.
Stigmatic order. And required to be a principle of natural justice to be required to conduct an inquiry.
Yes.
And granted with all other consequential benefit accordingly. Another judge agreed the views of the learner singer judge order. Then matter was referred to the honorable third judge. The third judge agreed the version of the honorable Chief Justice.
Yes.
And then thereafter I was reinstated. I was reinstated to service on 6/11/19.
Were discharged on 31/3/94.
94.
1991 of 94. You were reinstated on 6/11/96.
6/11/1997, 96 are reinstated. And I continued, I received all the consequential benefit. There is no dispute at all. Again, thereafter, the respondent issued the Saukash notice without without concrete material evidence and witnesses. And and denied and submitted the explanations. And then thereafter, again issued the termination order on 23/8/1997.
Yes.
Then I agreed by that order, I preferred a writ petition in writ petition number 8147 of 1998, which came to be allowed and granted with all other came to be allowed and granted with all other consequential benefits and continuity of service with full back wages, and also imposed 5,000 rupees cost to the respondent. And there was no dispute. They agreed that there was no dispute and accepted that. And then thereafter, again, I was reinstated to the service and received all the consequential benefits, including the cost. Again, after the 9 years, without any dispute, I continued in the service. After 9 years, from the date of disposal of the writ appeal, again issued the charge sheet on 14/2/2005. The same allegation split it into 14 charges. Without enclosure the statement of allegation, list of documents and list of witnesses, no detailed descriptions, and no names of document also they are not enclosed, and is clearly contrary to the rule 26 of KSSC, conduct and discipline and appeal rules. It is an admitted fact, and there is no foundation. Why they have issued the Saukaash notice come charge sheet after 9 years? Because the managing director established 3 petrol bunks illegally from the company act. The union of the respondent union, they filed a complaint before the Lokaita. Complaint has been registered. Under the impression that the appellant might have in hand in law in that complaint, for that reason they framed a vague charges, classes were made charges without any material evidence, and also no witnesses. And against that order, I preferred a challenge that order. I disputed. I challenged it before the Honorable Court in writ petition number 9159 of 2005. It came to be allowed and quashed the termination order and directed the respondent not to proceed on the same allegation further, and also imposed cost of rupees 10,000 rupees to the respondent.
Yes.
Well, then thereafter, they preferred an appeal. The appeal, in the appeal, they allowed the writ appeal. Again, they directed the appellant to furnish the explanation of the Saukaash note come charge sheet, and also further directed the respondent to conduct an inquiry in accordance with rule. Again, then thereafter, without providing any material evidence and witnesses, again they issued the termination order.
Yes.
That order has been issued the termination order on 8/3/2006. The termination order has been challenged before the Honorable Court by filing a writ petition number 1449 of 2008, which came to be allowed. Then held that the Honorable Learned Single Judge held that the respondent neither adduced the evidence by the witnesses nor placed any document before the inquiry officer. Again remanded back to the respondent to conduct an inquiry, where the inquiry stopped. But the Honorable Court has not passed the consequential benefit. The against the non-granting the consequential benefit have preferred a writ appeal. And during the pendency of the writ appeal, again the respondent hurriedly issued the termination order. But in the writ appeal, I succeeded. Again issued the termination order on 11/7/2012. Agreed by that order, termination order, I preferred a writ petition number 21936 of 2013, which came to be allowed and set aside the order of terminations and order for reinstatement, continuity of service, all other consequential benefit, and imposed exemplary cost, and also imposed 25,000 rupees cost to the respondent for victimization of the petition. Further held that the entire charges are vague and bereft of any detail, and respondent repeatedly victimizing the petitioner by colorable exercise of power. Then thereafter, the respondent against that order again preferred an appeal in writ appeal number 6359 of 2017, which came to be allowed part and set aside the order of Learned Single Judge, order of removal dated 11/7/2000 12, and again remanded back to the what the inquiry. Agreed by that order in the division bench, I preferred a SLP. And before that, I submitted representation to the disciplinary authority and also inquiry officer not to pass any order, not to commence the inquiry till disposal of the SLP. And after received the representation, they immediately they issued the termination without conducting an inquiry, without issuing the second inquiry report. And there is no witness, and there is no adduced the evidence. And then thereafter, again that order has been challenged before the Honorable Court in writ petition number 53029 of 2018 month. Then the Honorable Learned Single Judge held that with the consent of both the parties, appointed retired district judge as the inquiry officer to conduct fresh inquiry in respect of charge sheet dated 14/2/2005 with the consent of both the parties. And then thereafter, the court appointed inquiry officer conducted free and fair inquiry and submitted the inquiry report. For a moment, my lord, kindly turn the page number 398. Second one.
Yes.
Para 11, my lord, kindly turn the page. Shall I read? Para
Yes.
11, from reading of the charges which I have gone above, which I have given above, it becomes very clear that the charges are very vague and to be understood properly as they do not give any particular of the period, the place of occurrence where the alleged acts of misconduct have been committed or events with the constitute the misconduct have taken place. With such ambiguous and vague charges bereft of the necessary particulars, and when the article of charges are not accompanied with the statement of allegation also, the inquiry that is proceeded on the basis of the same will be vitiated and violate the principle of natural justice as can be understood from the dictum of lordship, this decision. On this ground alone, I feel that the DO, that means delinquent officer, is required to be relieved of the ordeal of the inquiry proceeding on the basis of the types of article of charges that is served on him. In view of the above discussion, I find it inappropriate to proceed to the inquiry on the basis of the article of charges served, along with the so-called notice dated 14/2005. And on the delinquents, it is also fundamental principle of law that the inquiry proceeding based on the charges framework not in compliance of the service rule, the entire proceeding thereupon holding the inquiry will be vitiated. Therefore, even if I continue the holding the inquiry against the DO, in this case, on the basis of the charges framed against him, it will be futile exercise and redundant. At this juncture, it has to be done in the mind of the Honorable Supreme Court in the case of Supra as also they observed. So, shall I read that is? Therefore, regard to this aspect of the observation, I am of the considered opinion that the entire file has been returned to the disciplinary authority. With this report, leaving it open to the consider whether fresh article of charges have to be framed, particularly the charges of disciplinary authority, and strictly in accordance with Rule 26 of KSIC 1980, and to take further action for initiating the disciplinary proceeding against the DO. In the result, I pass the following orders. In view of the fact that the article of charge served on the delinquent officer are not in accordance with and violative of Rule 26 of KSIC, Conduct and Discipline and Appeal Rules 1980. Leaving it open to the disciplinary authority to consider whether the fresh article of charge have to be framed by the particularized charges by strictly in accordance with the Rule 26 of KSIC Rules 1980 and take further action for initiating the disciplinary proceeding against the DO and to proceed toward the inquiry against him fresh. Well, agreed by this only leaving, only portion of the inquiry agreed by this portion of the inquiry report are referred as writ petitions. In writ petition number, there is a impugned writ petition, that is a 5559 of 2020. On the ground that the inquiry officer exceeding the jurisdiction, there is no statutory rule to recommend to the disciplinary authority, and there is no rule, and the charges are not in accordance with rule, and there is no foundation to initiate the inquiry. And also, while appointing the inquiry officer by the honorable court, I have not delegated any power to the inquiry officer to recommend beyond giving the inquiry report. The duties and responsibility of the inquiry officer end with by submitting the inquiry report. Accordingly, the filed writ petition came to be admitted, and order for entire back wages as consequential benefit with 6% interest on the arrears, and also imposed 1 lakh rupees cost to the respondent. For a moment, my lord, kindly turn the page number 421, my lord. It is a reported matter. The writ petition disposed while resolving the 4 core issues. The 4 core issues is kindly turn the page number, my lord, 432, para Walmart.
Yes.
Per contra, the learned counsel for the respondent vehemently contended that the petition has made out a case so as to interfere with the order of the inquiry officer dated 4/2/2020. The inquiry officer held that charges levied against the petition is not concerned with the rule 26 of rule 1980. Further, liberty has been given to the disciplinary authority to initiate fresh inquiry in the terms of rule 26 of rule 1980. Thus, there is no infirmity in the order of the inquiry officer, and it is for the disciplinary authority to take decision either to initiate the fresh inquiry or not. Pursuant to the inquiry officer order dated 4/2/2020, thus the petition has not made out a case as to set aside the later portion of the inquiry officer report. This is the core issues. 13, heard the learned counsel for the parties. The core issues involved in the present petitions are as follows. Number 1, whether delay in conducting the disciplinary proceeding vitiated the entire proceeding or not. Second, whether the inquiry officer could recommend for the initiation for the fresh inquiry or not. Then third, having regard to the materials, dates and events, whether a fresh inquiry is warranted or not, and what relief petition is entitled. Based on this, the entire question wise detail has been, facts has been elaborated with quoted the relevant citations. Finally, we'll come to the operative question.
Yes.
In the operative portions, writ petition is allowed. Second, in view of the aforesaid reason, legal position, the portion of the order, that is, leaving it open to the disciplinary authority to consider the article of charges have to be framed by particularizing the charges by and strictly in accordance with Rule 26 of TCC Rules 1980, and take further action for initiation of the disciplinary proceeding against the divorce, and to proceed over the inquiry against him fresh. The entire file is returned to the disciplinary authority of KCC Limited. Annex Q dated 4/2 is set aside, and remaining portion of the order reported 4/2 is affirmed. Then second, the respondent disciplinary authority is hereby restrained from taking further actions pursuant to the Saukash notice cum charge sheet dated 14/2005. Read with inquiry officer order report dated 4/2/2020. Third one is fourth one, sorry. Respondent are hereby directed to set aside the petitioner service condition which are due to him from time to time on par with his immediate junior in the service. Thereafter, the monetary benefit which are due to him shall be calculated and released along with the 6% interest. Then fifth matter, the above exercise shall be completed by the disciplinary authority / competent authority within a period of 3 months from the date of receipt of this order, failing which the petition is entitled to litigation cost of ₹1 lakh in addition to whatever monetary benefit are due to the petitioner by virtue of the service conditions. My lord, against this order, the respondent preferred an appeal in writ appeal number 504 of 2020 on the ground that the Honorable Learned Singh Judge has not given the sought time to file an objection to the writ petition. Though the Honorable High Court has given 135 days to the respondent to file an objection from the date of notice served and copies of writ petition served to the respondent, and finally has appeared and argued the matter has been recorded, which has been recorded in the judgment for which there is no dispute at all. Again, thereafter, the Honorable Division Bench again remanded back to the Learned Singh Judge for fresh order, remanded for fresh order. Then kindly turn the page number, my lord, writ petition 491, 421, Division Bench order. 457, sorry, 457. There are para 6. This court has selected.
Four?
My lord, 457. Next page, last para I read out the order.
Yes, please do.
Last, the para number 6. This court has carefully gone through the citation furnished by the respondent party in person. However, the peculiar fact and circumstance of the case as proper opportunity of hearing was not given to the appellant before this court. And also keeping in view that no reply or written statement as was filed to the writ petition, the judgment delivered by the Learned Singh judge deserved to be set aside. Accordingly, the writ appeal is disposed of. The order dated 27/2020 passed by the Learned Singh Judge in writ petition number 5559 of 2020 is set aside. The matter is remanded back to the Learned Singh Judge to decide the matter fresh in accordance with law. The appellant is granted 15 days time from today to file reply or written statement objection to the writ petition, and matter shall be decided fresh in accordance with law. Needless to mention that the Learned Singh Judge shall not influence it by his earlier order and shall decide the matter afresh in accordance with law.
Yes.
Well, this is the first stage of the disposal of the writ petition. The same writ petition, in the second stage of the disposal of the writ petition by the Honorable another judge, again order for the fresh inquiry with the time frame and different inquiries. Though both parties are not sought for the fresh inquiry, it is not a subject matter of the writ petition. And once the and there is no rule for the termination of a terminated employee, because appellant has been terminated in the year of 1983-2006. Till now, I not reinstated to the service, not placed under suspension for inquiry or further inquiry or fresh inquiry, neither provided the sought salary from the date of quashing the termination order, not provided the sought substitute allowance. For non-providing the sought substitute allowance, it is a clearly violation of the principle of natural justice and conducted entire inquiry proceeding become vitiated. My lord, once the termination order quashed by the Honorable Court, if the respondent wants to conduct a fresh inquiry or further inquiry, the charge sheeted employee shall be placed under suspension from the date of original order of the termination as per rule. But I have not placed it under suspension, but I have not reinstated and not placed it suspension and not provided the sought salary and not provided the substitute allowance. And there is no existence of the relation between the employer and employee. Till 2006 to till now also, till also not reinstated. There is no rule. My lord, for that, for a moment, my lord, kindly turn the page number, my lord, list of authorities. I submitted the extra copies of the rules.
Yes.
KSIC, list of authorities, KSIC conduct and discipline and ethics 20. That is kindly page number 12, my lord.
Sorry, first, second, ಯಾವ ಲಿಸ್ಟ್ ಹೇಳಿ ಮೂರಿದೆ ಅಲ್ವಾ?
List of authorities ನಲ್ಲಿ
ಕರೆಕ್ಟ್ ಅದು ಮೂರಿದೆ.
ಅದೇ ಇದು list of authorities ನಲ್ಲಿ ಮೂರನೇದು. ಮೂರನೇದು.
Yes.
My lord, instead of confusing citation, better I can highlight only the written argument which have been mentioned entire things.
Yes.
Is the company extract rules, man. Page number 12. Then para 4.
Written submission.
Written.
Yes. Yes.
Excellent. Page 34, my lord, in the written argument.
Yes.
34, sorry, 34, my lord. That is a 4, where a penalty of dismissal, only operative portion I'm going to read, my lord, because entire extracted, so where the necessary, I'm going to read only the operative portion. Where a penalty of dismissal or removal from the service imposed upon the employee is set aside or declared or rendered void in consequence or by a decision of the court of law and disciplinary authority. On consideration of the circumstance of the case, decide to hold further inquiry against him on the allegation on which the penalty of dismissal or removal was originally imposed. The employee shall deem to have been placed under suspension by appointing authority from the date of original order of dismissal or removal and shall continue to remain under suspension under further act. So that it is a clearly violation. So I have not been reinstated to the service and not placed under suspension, not provided anything.
Yes.
Regarding the substantial alignment. Well, rule number 20 of subsurveillance is clearly elaborated. All the whoever is the employees, charge sheeted employees suspended automatically, whatever rule will be there, 50%, subsequently increasing 75% will be there. In addition that, I'm going to read one more reported judgment, madam. Same 39 para, 35 para, sorry, page number 35, para 39. In the case of Affects Court, in captions, Paul Athani versus Bharat Gold Mines Limited, 1999. 3 SEC 679. Of course, while considering the payment of subsistence in case of government servant, had in fact observed that the act of non-payment of subsistence could be linked to slow poisoning. And if employee is not permitted to sustain himself on account of non-payment of subsistence, it would be gradually be starved to death. The Affects Court held that the payment of subsistence is matter of right and want. Another two reported matter has been filed in the list number 2, 1 and 2, 3 also.
Yes.
Well, for one charge sheet, cannot exist 2 inquiry report and 2 termination. Two inquiry report and 2 termination.
What are the charges against you?
Second, kindly turn the page number 190. $182 million in first value.
Yes.
182 million.
Yes.
Page number 196. only charges will remain. Charges, my lord. Charges number 196, page number.
Yes.
Lacks of capability hold the post of assistant sales officer and under utilization of the service of the sales staff on account of his inefficiency resulting causing the indirect loss to the corporation. Second, showing dishonesty and fraud in connection with the business or property of the corporation. Third, acting in a manner prejudicial to the interest of the corporation. Willful insubordination and disobedience of the lawful and reasonable orders of the superior. The negligence and lack of interest in the performance of his duties. Committing an act of discipline or of the good behavior. Committing an act and amounting to amendment of an act of amount to the misconduct. Making representation directly to various authorities, thereby deluging directly or indirectly official document or wrong information to the authorities, determined to the interest of reputation of the corporation under the guise of utilization of his grievances. Committing an act of resulting in loss of confidence and act in the manner detrimental to the interest of the corporation, resulting in mortgaging the confidence and integrity reposed on him by the corporation. Criticizing the officer of the corporation, making allegation against the officer of corporation and disregard of the reputation of the corporation and its the officer. The poor performance in discharge of duties throughout, indulging the cheating the customers and not mending his ways, in spite of which was warning, thereby proving himself in an incorrigible character. Heights of inefficiency and incorrigible act of executed throughout, thereby putting a negative contribution. Executing the attendance towards the officer of the company. I hereby directed to submit the written explanation of your defense on or before 22 with the submit explanation within the given time. It will be presumed that you have no explanation to offer and further a disciplinary proceeding will be initiated as per rules of the corporation. My lord, kindly.
Is there a statement of allegation?
No, my lord. There is no statement of allegation. No witnesses. Even single witness, there is no proof of single witnesses. Only in the interest of showing the witnesses, he hired a HR consultant. HR consultant is nowhere related to the charges. There is a judgment, specific judgment also quoted in the written argument. For a moment, my lord, kindly extracted in the written argument charges, how to frame a charges, what are the ingredient to be required.
Yes.
All the classes were made as a charges, Melia. My lord, in the list of authorities, list number 3, page number 70, extra copies of it.
Yes.
Rule number 26, procedure for imposing major penalties. Number 3, item number 3, where it is proposed to hold an inquiry, the disciplinary authority shall frame a definite charges on the basis of the allegation against the employee. The charges together with the statement of the allegations on which they are based shall be communicated in writing to the employee, who shall be required to submit within such time as may be specified by the disciplinary authority, not less than 7 days. Written statement whether he admits or denies any of or all the articles of charges. This is entire extract copies, full copies have been extracted in the written argument. And my lord, in the wage charges should not be served to the delinquent employee. The written argument para number, page number 13.
Yes.
The reported matter, Anant R. Kulkarni versus YP Education Society and others, Supreme Court, 2013, 6 cases, 515, para number 16. Thus, nowhere should be delinquent be served a charge sheet without providing him clear, specific, definite, and description of the charge against him. When the statement of allegation are not served with the charge sheet, the inquiry stands vitiated as having been conducted in violation of principle of natural justice. The evidence adduced should not be perfunctory. Even the delinquent does not take the defense of or make a protest that the charges are vague. That does not save the inquiry from being vitiated. For the reason that there must be fair play in action, particularly in respect of an order involving adverse or penal consequence. What is required to be examined is whether delinquent know the nature of accusation. The charges should be specific, definite, and giving detail of the incident which framed basis of the charges, and no inquiry can be sustained under vague charges. Having regard to the article of charges which are vague in the nature. The following expression used in the charge sheet have been held to be vague as lacking precision. These are the judgment to be required and defined whether charges are vague or not. These are the citation has been quoted in the written argument. In addition, in the charge sheet, my lord, page number 38, same written argument.
Yes.
Question number 3, para 44. Perusal of the date and event, that is 31/3/1994, the date of discharge for termination order on 23/8/1997, 8/3/2006, and 11/7/2004, 6/8/2018. Read with Saukash notice dated 14/2005. In the absence of statement of imputation, the charges leveled against the appellant are very vague. It is imperative the specific charges are framed in the clearest term with the full particularity. The charges are not to be vague and should state in a definite term the allegation on which they are based and grounds which have led to the authority to take action. The language used should be clear, free from the ambiguity, whereas the article of charges in the present case are not supported by statement of imputation, since the employee is to be informed not only the charges against him, but also of the evidence on the which those charges are sought to be established so that it can be forwarded as defense. The charge sheet usually consists of forwarding letters, Saukash notice, and 4 annexes. That is article of charges, statement of imputation, / misconduct and misbehavior. Charges is based. List of document, list of witnesses. In the Supreme Court reported judgment versus State Bank of India versus Narendra reported in CA number 263/ of 2013, dated 14/1/2013, wherein it was held that the inquiry is vitiated on the ground that failure to mention the names of witnesses and document in the document. It is support of the charges, in support of the charges.
Yes.
My lord, the charges, initially charges are not concerning the rule, or charges not in accordance with rule. If conducted inquiry, entire inquiry become a vitiated because there is no foundation. For that, I would like to read one more reported judgment.
Yes.
My lord, page number 32, written article. 35 para number.
Yes.
The charges are not in accordance with rules. The entire proceeding become vitiated. In the case of Suresh Ram versus State of UP through the additional Chief Secretary / Principal Secretary PWD, the Supreme Court of India 2019 Supreme all 2280 AD 64. Number 20. The Honorable Apex Court in the State of Punjab versus Devendra Pal Singh Bulla and others connected with the Samu Singh Sai, Devendra Pal Singh Bulla and others 2011-14 SEC 770 has considered the aforesaid maximum in para number 107 to 111, which are being reproduced here below. My lord, it is a 107. It is certain legal proposition that if initial action is not concerned with the law, subsequent, all subsequent and consequential proceeding would fall. Through for the reason the illegality is at the root of the order.
We understand the contentions. We understand the contentions. What is the reply? When will you?
My lord?
When will you reply to the arguments?
But 1 week. Otherwise, my lordship, I leave to lordship because some problem in the eyes and only I am not able to read. That is, even though if lordship says no has to be done means I will read. That is no issue, my lord. But here, my lord, so all this, only one submission I will make, my lord. Now this order passed that the order which he has challenged, my that order has, that petitioner has not read, my lord. All these things, whatever said, vague and all, everything has mentioned in the detail in that order, my lord. Now, my lord, this petitioner's prayer is to pass that order. Now this matter, against that, this appeal has been filed. This appeal, my lord, your lordship may say that orders of this that honorable division bench, my lord, that in the daily orders, everything is mentioned. And there, this lordships had said that the inquiry has to be proceeded further, and we have gone through everything. And that inquiry was.
These are the charges on which.
These are all the charges, these charges are.
The charges. What has been read are the charges on which an inquiry has been conducted.
Yes, well, same charge sheet, my lord. Same charge sheet, same charges, my lord. That this honorable division bench has permitted the corporation to proceed with the inquiry. And they said that you should not impose the punishment and you have to wait and you have to inform us. Then accordingly, the inquiry was conducted, all the as per the procedure and all, and petitioner also participated in the inquiry, and the inquiry officer found him guilty of the charges, and that report was placed before the honorable division bench.
Therefore, it should
See here, my lord, just one order, my lord, that daily order passed, my lord. One order I'll read. What is that order they mentioned, my lord?
My lord, it is his intention to misleading to the court. And
No. What he is talking misleading?
This is the order, it came to like
when
this.
you were arguing, the Respondents' Council did not say.
Sorry, my lord.
Please sit down. Yes.
My lord, that my memo, my lord, that is my lord one.
Synopsis, sir.
Synopsis, this and all given earlier, my lord, I submitted one memo, my lord, that is on 15th December 22. There I mentioned the daily orders passed by this honorable court.
Date ಹೇಳ್ತೀರಾ sir?
Memo.
Never mind. What is the point you wish to make?
In that, there, my lord, that this honorable court, they have considered all these things. Then they said that then after going through our findings of the inquiry officer, the honorable court said to proceed with the inquiry, proceed further.
Subject to result of the writ appeal.
Subject to writ appeal. Yes, my proceed.
Why we are hearing it on the merits of the matter.
My lord, then.
Please don't go back to the interim orders passed. Please tell us as to, are these the charges on which an inquiry has been conducted?
Yes, my lord.
And going by the principles that have been stated here, is it possible to conduct an inquiry on charges which are so general in nature? That is the point you have to answer us.
Yes, that I'll answer, my lord. That's already in the arguments.
Charges are to the effect that he did not improve his performance even after being even after his probation was not declared and his services were discharged for want of not meeting the benchmarks. Then that the charges appear to be very general in nature. The decisions are to the effect that the charges have to be specific and the statement of allegations has to say on what material you're raising the charges.
Yes, ma'am, that's.
The witness list has to be given. These are the provisions for conduct of inquiries. The
Yes, ma'am.
contention appears to be that
Yes.
this is followed only in their breach in the present inquiry.
In the writ appeal, my lord, all these points are explained in detail. That I'll read, my lord. Whenever I read that, I'll read.
Yes, we'll hear you on that. Next week,
Next week, on
on what date do you want it? We'll have it on 2:30 on a particular day. We'll finish the. 2:30 list and
whichever the date your lordship is,
because
I'll come.
it is now a parted matter. We have
Yes,
to
yes, yes,
hear
ma'am.
you at the earliest.
Yes, yes. Any date your lordship. Next week,
Next,
because I'm undergoing treatment next week, it's okay, my lord. I'll,
next Thursday,
yes, my lord.
yes.
Sir. 14th. 8th August.
8th. Much obliged.
Yes,
Serial number
Good, sir.
51, next matter.
yes.
There is real urgency in the matter and matter to be heard, my lord, on priority because about 850 or 890 employees, timescale forum workers working throughout India at various centers, established by the Central State Board are the beneficiary of the award passed by the Central Government Industry Tribunal, where age of retirement is enhanced from 55 to 60. Then, my lord, a writ petition is filed because of the interim order is, my lord, they have to be continued till 58 years. Then, my lord, when this matter was referred to the division, earlier matter was under single judge. When the matter was by special order referred to the division bench, this honorable court, looking at the time being taken by the learned advocate appearing for the Central State Board, that is the petitioner, said, my lord, any retirement before 60 years is subject to the result of the writ petition. Only on that ground, my lord, my learned friend always seeks time and all. Anyway, today, my lord, even if the matter could be heard, I have called, my lord, time is already 4:40. Because of the urgency, my lord, may I
Writ petition has been referred for, to the division bench for a hearing?
Yes, my lord.
Writ petition referred to the division bench for a
Yes,
hearing?
yes. That is on 18th January 2020 special order. Why, my lord, this matter was, it is by the industry tribunal. Why this matter was referred is, the award passed by the tribunal, as I just now mentioned, 55 to 60 years. Based on that, my lord, some of the employees, these who are the beneficiaries, they directly went to the CAT and they got the interim order that because of this award, they must be continued. But that was contrary to the interim order passed by this honorable court, staying the operation beyond 58 years. That's why, my lord, those CAT orders were challenged by the Central State Board. When they were being heard, my lord, this honorable court felt that it is a case where if that award issue, which is the main issue, my lord, in this particular writ petition, is decided, that will put an end to all the litigation. That is why, my lord, this is before the honorable division bench.
Is it the
Yeah,
contention that? an
twice, my
award-
lord, this matter was heard at length.
Is it the contention that an award cannot be passed in such?
Award
a-
cannot be.
Is it the contention that an award cannot be passed by the tribunal in such matters? What is the contention?
Their contention is, my lord, 55 to 60 years, my lord.
On the question of jurisdiction of the
Yes.
tribunal to pass an award, what is the contention?
There is no such contention. They have not taken any such contention. They only contend, my lord, that very award is erroneous.
That is all.
But they admitted, during the pendency of this writ petition itself, they admitted, yes, 55 to 58 is no objection. So all of the technical issues they raise.
55 to
maintained.
58, they have passed orders enhancing the age limit,
Yes,
the retirement age,
yes.
that orders have been passed.
No, we are continued till 58. Immediately, my lord, we reach the age of 58 years, we are retired from service. But there is an interim, yes,
Counsel, it was 55 earlier.
yes,
The award said 55 to 60.
60.
Now they are continuing you till 58. So
Yes.
there must be some order or some decision taken by them.
No, because before the labor court itself, I got that interim order to continue till 58 years,
Cannot
before the
be.
tribunal.
Cannot be on the basis of an interim order. There must be a decision taken to enhance it from 55 to 58.
No, under section 10(4) of the ID Act, there is an interim order. That interim order came to be challenged. That interim order came to be challenged before this honorable court in the earlier batch of
So
it.
there is an award comes
Yes, yes. Award is 55 to 60 years.
55 to 60.
Yes,
They are continuing you till
up to
58
58.
on the basis of some order passed by them.
Yes, exactly.
Yes.
At the time of admission.
Yes, we'll
First
consider.
order. Now, because of the urgency, may I request you last to kindly have it next Wednesday. There is serious urgency, my lord. Only few of them are before the court.
Place whatever materials you are placing, decisions or whatever, please make it available in the form of a written synopsis. We'll hear you next week.
Next.
Second set of IS ನೀವು ಹಾಕ್ಬೇಕಾ ಅವ್ರು ಹಾಕ್ಬೇಕಾ sir?
I think everything is,
Who is
Second
appearing?
set.
Who appears for the
One Mr.
petition?
Narasimha Swami. Earlier, Mr. N.S. Prasad was appearing, now Mr. Narasimha Swami. All pleadings are complete, my lord. Even second set is also before the court.
Written synopsis.
Be filed ಅಂತಿದೆ. Second set of all IA papers to be filed. Only single set is there ಅದಕ್ಕೆ ಹೇಳಿದ್ರು.
Please make available the second set because it was a writ petition. Once it is referred, two people are here. We must see the documents. Please make available the second set and please also make available.
My instructions are Mr. N.S. Prasad filed those documents also. He has filed. I don't know why, my lord, that still that note is there. If I am correct, my lord, they are filed. Synopses are filed.
If everything is ready for hearing, then list it.
In fact, very interesting thing is.
Yes,
after
please
this
make
mat-
available the synopsis also.
Yes, after this matter was fully heard, before the matter could be reserved for judgment by the earlier Honorable Division Bench, the Honorable Division Bench directed the parties to file bullet points. Even that is also done. List of authorities are also before the court.
Yes,
Next seven, whatever it is.
please verify that it is ready for hearing. We'll hear it on someday next week. 14th August. 14th.
My lord, serial number 52, my lord.
What day?
Monday, 20th.
20th August.
20 to 22, I have some difficulty, personal thing, because of some religious function. Earlier to that, if it is possible.
22nd.
20, 22nd, there is some problem for me. Some Aradhana and all that.
9th, may not be possible.
27th.
19th not possible, madam. Monday.
ಆರಚ್ಚಿದೆ sir ಮತ್ತೆ.
Next Thursday or Friday, next Thursday, madam.
List it on 9th if everything else work time. 9th.
9th ನೋಡೋಣ sir. 9th August.
9th August. I'll take 9th August.
Yes, item 52 stands dismissed as withdrawn.
Very well, my lords. That was what I wanted to understand. Thank you, my lords.